sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
We get started. All right, I've started the live stream. So what I have is Miss Bruner, Angel Bruner. We're going to continue her until tomorrow. Mr. Harris, Justin Harris, he did first appearance yesterday and he had a bond, so we're not going to deal with him today. And Miss Destiny White is going to be continued until tomorrow. Now, Miss Mary, can you hear me?
I can.
We have Miss Cunningham, Sophia Cunningham, but it's also listed as Sophia Cunningham Laird. How is she listed on your calendar? Is it Cunningham?
It's showing her last name is Laird, Sophia Cunningham.
Yeah, on the warrant and on my bond sheet is showing as Cunningham. And because Miss Mary is going along with me, I want to make sure that I put her in whatever order it is on the calendar so she doesn't have to go flipping through the calendar to put the information in.
Well, she's not listed as Cunningham. What's the other one? Laird, L-A-I-R-D?
Yes.
Yeah, she's listed as Laird, L-A-I-R-D.
On your calendar?
On the calendar, yes.
Okay, so I'm going to call her in that order as L-A-I-R-D. All right. Is there anything else that we need to take care of before we get started?
No, Your Honor. In reference to Mr. Grayer, is he going to be last, or do you want him to go in alphabetical order as well?
I'm gonna save him till last. Oh, and that brings up one other thing. Because we have a female fugitive and two male fugitives, do you want to do all the fugitives at the same time?
Yes, Your Honor. It's actually two females and one male.
Two females and one male. Okay.
Yes, Your Honor.
All right. Thank you. Okay, I'm ready to start.
Yes, Your Honor. Thank you.
Okay, good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise your right hand for me, please. Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, sir.
Thank you. Thank you. Let's begin with the ladies. I believe we have Miss Alexander.
Yes, Your Honor, she's present.
Okay. Ma'am, you're charged with 1 count of murder, 1 count of aggravated assault with a deadly weapon, and 1 count of armed robbery. I am unable to set bond at this proceeding on these charges. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning. You're going to have a bond hearing date set at a later date because these charges, the bond hearing has to go before a superior court judge.
Okay.
Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Johnson. Jasinski, you know.
Okay. Is it Jasinski or Johnson?
No, Ashley Johnson.
Okay. Ms. Johnson, you're charged with 1 count of giving a false statement. This is a felony offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Deshaun Boyd. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No questions at all.
Okay, ma'am. I'm sorry.
No, you said the bond is $5,000?
Yes, ma'am.
Okay.
You're free to go back.
Okay, thank you.
You're welcome. Miss Jasinski.
Cunningham, you're next.
Ms. Jasinski, ma'am, you're charged with 1 count of family violence battery and 1 count of criminal damage to property in the 2nd degree. The criminal damage to property in the 2nd degree is a felony offense. The family violence battery is a misdemeanor. Bond is going to be set at $5,000 for the family violence battery and $5,000 for the criminal damage to property in the 2nd degree. There's going to be a stay away provision on this bond to stay away from a Jacari Odom. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
So $10,000 together for the whole bond.
Yes, ma'am.
Okay, thank you.
You're welcome. You're free to go back.
Cunningham,
Okay.
Odom, you're next.
All right. So, and ma'am, is your true and correct last name Laird?
No, I'm divorced. It's Cunningham.
Okay. Ms. Cunningham, ma'am, you're charged with 1 count of simple battery. Bond is going to be set at $5,000. This is a misdemeanor offense. I did not place a stay away provision on this bond because the victim is your adult son.
Yes.
Does your son live with you?
Yes, he does.
Do you believe that you can live in this home without the police being called back out?
Yes.
Okay. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. Do you have any questions of me?
Yes. During the time of the arrest, the arresting officer never read me my Miranda rights. And he said it was video record, so you should be able to see that. My Miranda rights was not read to me. He said, you're going to jail, and that was it.
Okay, so it's commonly misunderstood that Miranda rights have to be read. Miranda rights have to be read if law enforcement intends to use any statements that you may have made against you. Okay, so and that applies to custodial questioning. So if an officer arrives on the scene and you say, I did it, officer doesn't have to read you Miranda rights. But if you're a suspect and they believe that you did it, that may be something that your rights have to be read. But that's a discussion that's better had between you and your lawyer. And with there being body cam footage, that'll tell the day. However, in cases like this, where there's a complaining witness, if the complaining witness says she did it, that's enough. You can say, I didn't do it all day. And the person said you did it and you still could be convicted. Okay?
Understood.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Odom.
Salgado, you're next.
Ma'am, you're charged with 1 count of battery. I'm going to set your bond at $2,500. I'm going to place a stay away provision on this bond, stay away from Mr. Ansel Claiborne Toric Johnson. Do you understand that, ma'am?
I understand.
Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer? You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Thank you.
Okay, you're free to go back. Miss Salgado. Miss Salgado, ma'am, you're charged with 1 count of simple battery. I've set the bond at $5,000. There's going to be a stay away provision on this bond, a stay away from an Axel Nava. Do you understand that? Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer? Okay. Do you have any questions of me?
Yes.
Go ahead.
My question is, when I call police, I call because he's aggressive with me, and I have broom in my hand, and he lying to the police. I don't know. He had a report with my little girl, and he trying to squeeze her, and
Miss, ma'am, yeah, you don't want to discuss the facts of your case. It's best to have that discussion with your lawyer. The thing that most people don't understand is when you call law enforcement to your home, they have an independent duty to investigate the case and make whatever decision they seem to be right. And a lot of times people call thinking they're right when they're actually in the wrong. And if the law enforcement officer determined that you were in the wrong and they made the arrest, they made the arrest. But the state has to prove your guilt beyond a reasonable doubt. So they still have to prove that you are guilty of this offense. Okay? All right. You're free to go back, ma'am. Okay.
Robin. And the other one, you know, Nate. Well,
Nate, yes.
you know that.
Okay, let's see. All right, ma'am, can you identify yourself? Okay, and you are Miss Nate? And you are Mr. Harris?
Yes, sir.
Okay, so I'm about to tell the three of you something that applies to you all equally, but then I'm going to go to Miss Sproggins, Miss Nate, and then Mr. Harris as it involves your individual circumstance, okay? So all three of you are here on what are called fugitive from justice warrants. And what that basically means is that there is a warrant for your arrest out of another state. And that law enforcement contacted the other jurisdiction and they said that they do intend to extradite you, meaning they intend to bring you back to their jurisdiction to face whatever charges that are outstanding. You have the same rights and privileges as I discussed earlier with everyone else. But in your situation, you have the right to challenge that warrant. And there are two basic conditions that are challenged in the warrant, whether you are the person named in the warrant and whether the warrant actually is a valid warrant. So if you were to choose to challenge the warrant, sometime between now and the next 90 days, there will be a hearing in Clayton County to determine whether, one, you are the person named in the warrant, and two, whether the warrant actually names a charge. If those two conditions are met, then the judge will sign off on it and the requesting jurisdiction will receive notice. At that point, the requesting jurisdiction has 30 days up to 60 days. They can request a 30-day extension to come and extradite you, come and pick you up and take you back to the jurisdiction. If you believe that you are the person that is named in the warrant, and if you believe that the warrant has is valid, you can waive that whole process. And then that 30 to 60-day window begins to run today. If at the end of that 30-day period, you have not, they have not come to get you, Clayton County will call and say, hey, do you still intend to come get this person? And they may say, no, we're not gonna do it. And if that happens, you'll get released out the front door, but the warrant will still be valid. So you can be released out the front door, and 5 minutes later, you run into a law enforcement officer. They run your information. They see the warrant is valid. You go back into custody, and the process starts all over again. Is everybody with me so far?
Yes, sir.
Okay. So for Ms. Sproggins, the allegation is that you are wanted out of, is it Oskaloosa? Or Okaloosa County Sheriff's Office in Florida. There's a warrant for simple assault, and they're listing it as a felony. And I don't know the laws in Florida, so I'm assuming that that is a felony. For Ms. Nate, you are wanted by Miami-Dade Police Department in Florida for assault. And they're saying it's a felony, and they're saying that they will extradite. I'm sorry, ma'am.
We didn't say that. We didn't say that. The guy.
Okay, I couldn't understand. Ms. Nate, did you ask about Florida?
No, it was a guy.
Oh, okay, okay. Okay, I'm
like, dang, all of us wanted out. I just read the paper saying all of us basically wanted out of Florida.
Hold on one second, Mr. Harris. It's Escambia County, Florida, and it says a probation violation warrant, and they're saying it's a felony and they will extradite. So what I always encourage everyone is, as soon as possible, to get an attorney in whatever jurisdiction that is requesting you, because especially now during the COVID related times, and everybody's case is different, but some places they don't want to travel. And so if you hire an attorney and your attorney goes and speaks to the prosecuting authority down there, the next day I've had bonds come back from whatever the last one I think was out of California, where they said, hey, we've made conditions, or we made preparations out here, and release them. And so we released the person because we don't really care about your case or your charges. We're holding you because if we had a person that was in Florida that we wanted to extradite, we would want and expect for the law enforcement authorities in Florida to hold that person until they receive word. So, Ms. Sproggins, do you have any questions about this process? Do you have an idea of what you want to do?
I want to sign and waive that.
Okay. Okay. Ms. Nate, do you have any questions about this process?
No, sir.
Do you know what you want to do?
Yes, I want to sign this waiver.
Okay. Mr. Harris, do you have any questions about this process?
No, sir. I'm gonna sign my waivers.
Okay. So each one of you, when you sign the waivers, they're going to send the paperwork over to me, and I'm going to sign it. And then that clock begins to run today. But I do encourage each of you to try to get a lawyer to help assist you in whatever jurisdiction is requesting you. Okay.
Yes, sir. All right.
Okay. All right. So I think that ends. You can go off, Mr. Harris. I think that ends on the ladies' side. So ladies, once you sign those, they'll send it over. Is there anything else we need to do on the ladies' side? Okay. Okay, let's switch over to the male side. We're going to begin with Mr. Billingsley. Mr. Billingsley, sir, you're charged with 1 count of murder, 1 count of terroristic threats or acts, 1 count of criminal attempt, 1 count of criminal damage to property in the 2nd degree, 1 count of possession of firearm or weapon during the commission of a crime, and 1 count of aggravated assault. I cannot set bond on the murder and aggravated assault count at this time, and I've denied bond on the other offenses. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're also going to have a bond hearing date set, but that's going to be determined because that also has to go before a superior court judge. Would you like for me to appoint you a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Billingsley. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Ryan.
Mr. Bland, sir, you're charged with 1 count of criminal trespass. That's a misdemeanor. Bond is going to be set at $5,000. You're charged with 1 count of aggravated assault on a peace officer. Bond is going to be denied on that offense. And you're also charged with false imprisonment. Bond is also going to be denied on that offense. You're going to, there's going to be a stay away provision on this bond to stay away from a Francis Bland. Do you understand that, sir?
Is this new or is this the old one? Because I have another case with the same charges exactly, and I haven't had anything since then. I haven't been arrested. I've been locked up since.
Okay, when did that happen?
The initial was 5/9, May 5th. I mean May 9th.
Okay, this is from it says 5/8.
I've been in here since 5/9.
Okay.
So the other one that's on 5/11. I've been in here since, and I haven't spoken to no officer at all. And I couldn't trespass or false imprisonment anybody because I'm in here. And then I don't know.
Hold on, Mr. Bland. Hold on. Okay, so all 3 charges stem from 5/8.
Now it's 5/8, which
when you say now, I said 5/8.
So the one you just named is from 5/8?
Yes, sir. The dates for all 3 warrants say on 5/8/2022.
Does it say when it was issued?
It was issued on 5/17 of 2022.
How's that possible?
Because that's when the officer went to get the warrant. So these warrants are not, these are what are called, we call them CWs for short. Stop. Let me explain it to you. And then if you have questions, ask. Okay. So a CW for certain serious offenses, there's a detective assigned. The detective investigates. When the detective believes that they have enough information, they come to a judge and seek a warrant. So I've done warrants for stuff that happened 6 months ago. Okay, so did that answer your question?
Somewhat. Wouldn't I have been arrested on 5/8 then and not on the 9th?
Sir, were you arrested on 5/8?
No, not at all.
When you were arrested on 5/9, where were you arrested? What were the charges?
Those same 3 charges you just named, and those are the only time I've been arrested since last 2020.
Okay, and you were given bond? Hold on, you were given bond?
I had to go to my preliminary that's on the 25th, and that's when I was going to get a bond for the aggravated assault, the 1. Now it's 3 coming up, and I've only been arrested 1 time within the past 2 years. Period.
Okay. Do you have a lawyer appointed already?
Right now, no.
Do you want to have a lawyer appointed?
I mean, I would like for something to go into motion because I've only been arrested one time for those 3 charges.
Mr. Bland, I asked you a real direct question. I would like a real direct answer.
Yes, sir.
All right. See how communication can be effective?
Right.
You did not fill out the form, Mr. Bland. Are you currently employed?
I am.
About how much do you make per?
Well, being here kind of messes with that, but I'm gonna say about $2 grand a month.
Okay.
25.
Hold on one second. So it appears that you have already been appointed a lawyer for those other charges. So what you're saying, Mr. Bland, it rings true to me as a possibility. Okay. What could have happened is that when it got to an investigative stage, they say, you know what, these charges, they're not going to stick. So they may have went and gotten warrants through a judge, and they may be dismissing those other charges and moving forward on these charges.
Can they do that within their right?
Yes, sir. They can. And that's why it is important to have a lawyer as soon as possible, because the lawyer may have found something that was wrong.
Right.
And then they realized that something was wrong and said, these charges are going to get dismissed. We need to go and fix it.
Yeah.
I don't know, but that's where talking to your lawyer, and you may not have, appears like you haven't spoken to anybody. Okay. So what I'm going to do, Mr. Bland, is for today, I'm going to set the preliminary hearing for June 1st, but you indicated that you believe you're going to have a preliminary hearing when?
I have one on the 25th.
25th. Okay. So I'm going to check into this, and if these are the same charges out of the same set of facts, this may be something. Okay. This may get placed on the 25th calendar instead of June 1st. Okay. But I've been told that you have a lawyer, and I am going to, let's see. Looks like Judge Bridgewater is going to be conducting the hearings on that date.
But if go ahead, sorry.
Thank you, sir. It looks like Judge Bridgewater is going to be conducting the hearings on that date. Do you have any other questions for me, Mr. Bland?
If on the 25th, if I was to get a bond, would that be everything combined at that point?
Yes, sir.
Okay. That's it then.
Okay. All right. You're free to go back.
Thank you.
You're welcome. Mr. Boswell. Mr. Boswell, sir, you're charged with 1 count of murder, 1 count of aggravated assault with a deadly weapon, and 1 count of armed robbery. I cannot set bond on the murder and armed robbery charges at this junction, pursuant to statute 17-6-1. So I'm denying bond as it relates to the aggravated assault charge, and I'm going to allow one judge to just deal with all of this at the same time. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning. That's going to be courtroom 201. Your bond hearing is going to be determined because it has to go before a Superior Court judge in Clayton County. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Boswell. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Burgess? Mr. Burgess, sir, you're charged with 2 driving-related offenses. And you're charged with 2 driving-related offenses, and these bonds are set by schedule, which means they're automatically set. So for the failure to stop or yield at a stop sign, bond is going to be set at $500. For driving a vehicle without a valid license, bond is going to be set at $1,000. So you're going to have a total bond of $1,500. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Burgess. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. Thank you.
Okay, you're free to go back.
All right.
I'm sorry, tell me those amounts again.
Oh, $500 for the stop sign and $1,000 for the driver's license.
Okay, thank you.
You're welcome. Mr. Butler.
Sir.
Mr. Butler, sir, you're charged with 1 count of violating Georgia seatbelt law. Bond is going to be set at $500. You're charged with 2 drug-related offenses, possession of more than an ounce of marijuana and possession of marijuana with the intent to distribute. I'm going to deny bond on both of those felony charges at this time. You're also charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're going to have a bond hearing date set for June 3rd at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
You got the paperwork, don't it?
So
Yes, sir. Yes, sir.
you do qualify. I'm going to appoint a lawyer to represent you. You're free to go back.
Wait until he's done with you.
He can go back. Mr. Davis. Mr. Davis, sir, you're charged with 1 count of battery. Bond is set at $5,000. You're charged with 1 count of criminal trespass, damage to property. Bond is set at $5,000. And you're charged with 1 count of hijacking a motor vehicle. I cannot set bond at this stage on that offense. So bond is going to be denied pursuant to statute 17-6-1. There's going to be a stay away provision on this bond, a stay away from a Kendrick Mobley and a Tamika Minor. Do you understand that?
Yes, sir. I got a question for you.
Okay, give me 1 second. Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for June 3rd at 8:30 in the morning, courtroom 201. Now, do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, what was your question?
I was really finna ask about the bond hearing, but you said it was gonna be June 3rd.
Yes, sir.
All right, thank you so much.
You're welcome. Mr. Harris has been sent back. Yeah, first appearance yesterday. Mr. Henderson. Mr. Henderson, sir, you're charged with 1 count of criminal trespass. This is a misdemeanor. Bond is going to be set at $3,000. There's going to be a stay away provision on the bond to stay away from a Kenyatta Bashan Murphy. Do you understand that, sir?
I gotta stay away from her?
Yes, sir.
That's my wife.
She's a alleged victim also.
So, we stay together, so how did that gonna work?
As long as she's at that house, you cannot go back.
Okay,
Or you're gonna face felony aggravated stalking, and your bond will be denied, and you'll sit in jail until this case is resolved.
so I gotta stay away from till the case is over with?
Unless there's a change or modification of the bond condition, which can happen, but that'll happen either through a hearing process or through the Solicitor General's office making a request for the bond to be changed, or I'm sorry, the condition to be modified.
Okay.
Okay, and just so you understand, we don't know if this was just a little incident or the police got there right before you killed somebody. So we take the approach that the police got there before somebody was killed until we figure out no, and then the conditions are lessened.
Right.
Okay, your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you qualify. Mr. Henderson, I'm going to appoint a lawyer to represent you. Do you have any more questions of me, sir?
Yeah, how do I get a criminal trespass on my own home?
So property can be jointly owned or it can be solely owned. As you said, she's your wife, so there could be an issue of joint property. I don't know. That's where the hearings and all of this stuff come out to flesh that out. If it's joint property and you interfered with her ownership of the property, that could lead to criminal trespass, because the statute, it says knowing or maliciously interferes with the possession or use of the property of another person. So in this instance, the allegation is that you pulled the fuses out of the car and she couldn't use the car. Okay. All right.
How much you sell my bond? 3,000?
Yes, sir.
Okay.
All right. You're free to go back.
Thank you.
You're welcome. Mr. Howell. Sir, you're charged with 1 count of driving on a suspended license. That's a misdemeanor offense. Bond is going to be set at $1,500. You're also charged with possession of a firearm by a convicted felon on first offender probation. I cannot set bond on this offense, so bond is going to be denied pursuant to Georgia statute 17-10-1. You're also charged with driving a vehicle with no tail lights. Bond is going to be set at $500. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for June 3rd at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah, why can't set bonds on first call situation?
Okay, hold on. I'll get to that. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify. Under Georgia law, if a person is on probation or parole and that person is arrested on a felony offense or on a misdemeanor offense involving a crime of violence, judge at the first appearance cannot set bond. Doesn't mean you can't get bond tomorrow, but I cannot set bond at this first hearing by law.
What do you mean bond tomorrow?
What do you not understand about that?
You still mean I can't get it tomorrow, so why are you saying tomorrow then?
So theoretically, your lawyer can contact the district attorney's office and say, hey, this is the warrant. This is the incident. I've spoken with the probation or parole officer. They're okay with him being released on bond. And then if they agree, they'll consent to a bond.
I don't understand if I'm not on probation or I'm not on any probation right now.
Okay.
I'm not on no probation right now, that's what I'm saying. I don't understand.
Do you want me to look again?
Yeah, I don't have no probation.
Okay.
Nothing, no probation at all.
Okay. So it says you have 19 cycle, well, 20 cycles. That means interactions with law enforcement. And the 20th was on May 17th. Your last interaction before then was May 21st of 2020, probation violation related to a charge out of DeKalb County. And that is what I'm seeing as showing. Okay. So do you understand where this is coming from?
Yeah,
okay. So these records can be wrong. I cannot look at the records and disregard what I'm seeing. So that's what I'm saying about if these records are wrong, your lawyer can quickly get this taken care of. Any other questions?
So I need to go to DeKalb County. That's wrong.
I'm sorry?
I need to be reaching out to DeKalb County. That's what you're seeing in DeKalb County for probation?
Yes. Anything else?
No.
Okay, you're free to go back. Mr. Jackson. Mr. Jackson, sir, you're charged with 1 count of simple battery, family violence. Bond is going to be set at $4,000. There's going to be a stay away provision on this bond to stay away from Antiana Jackson. Do you understand that?
Sure.
Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
All right, yes, sir.
Mr. Keith. Mr. Keith, sir, you're charged with 1 count of obstructing an officer. That's a misdemeanor offense. Bond is going to be set at $2,000. You're also charged with giving a false name, address, or date of birth to a police officer. Bond is also going to be set at $2,000. So you're going to have a total bond of $4,000. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Keith. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Kennebrew.
He just stepped out, y'all. Next week, Mr. Mays. Mays.
Okay, what happened to Mr. Kennebrew?
He stepped out to use the restroom.
Okay, okay. Mr. Mays. Mr. Mays, sir, you're charged with 1 count of violation of Georgia Controlled Substance Act. That is a felony offense. Bond is going to be denied at this point on that charge. You're also charged with driving a vehicle with an expired tag. And the reason I'm denying your bond, Mr. Mays, is because you were arrested last month. And looks like you were on my May 4th preliminary hearing calendar. So getting arrested in 2 months on felony charges, I'm gonna have to deny your bond at this point. You're gonna have, hold on, sir. You're gonna have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. That date, well, you're not gonna bond out. I'm gonna give you a bond hearing date of June 3rd at 8:30 in the morning, courtroom 201. Now, I interrupted you. What did you want to tell me? Okay. Mr. Meadows. Mr. Meadows, sir, you're charged with 1 count of battery. Bond is set at $5,000. There's going to be a stay away provision on this bond, a stay away from Vanessa Meadows. Do you understand that? Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Nelson. Mr. Nelson, sir, you're charged with 1 count of possession of drug-related objects. That's a misdemeanor offense. Bond is going to be set at $1,500. You're also charged with 1 count of simple possession of a Schedule I narcotic. Bond is going to be set at $3,000. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, sir, you're free to go back.
Your Honor, Mr. Kennebrew is back.
Okay. Mr. Kennebrew.
Yes, sir.
Sir, you are charged with 1 count of essentially failing to pay your fare at the MARTA. I set the bond at $1,000, which is the lowest amount that I can set for you to be able to go through a bonding company. You're going to have a preliminary hearing date set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Kennebrew. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Okay.
Mr. Oliver. Mr. Oliver, sir, you're charged with 4 misdemeanor offenses. The first charge is speeding. Bond is going to be set at $1,000. The second charge is fleeing from police officer. Bond is going to be set at $2,000. Third charge is improper lane change or failure to maintain lane. Bond is going to be set at $500. And reckless driving, bond is going to be set at $1,500. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. I can't understand this. Are you currently working or not?
Yes, I'm freelance doing home improvement.
Okay. About how much would you estimate that you make per hour?
About 20 to 25.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, could you tell me my total bond?
Yes, sir. It's going to be $5,000. Okay. All right, sir. You're free to go back. Mr. Patillo.
Yes, sir.
Mr. Patillo, sir, you're charged with 1 count of possession of or use of drug-related objects. That's a misdemeanor offense. Bond is going to be set at $1,500. And you're also charged with simple possession of a Schedule I narcotic. Bond is going to be set at $3,000. Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify. Mr. Patillo, I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I do. My first question is, one, I wasn't Mirandized, or however you enunciate it. And my second statement is that the police officer asked, can he search my bag? I allowed him to search my purses, but I did not allow him to search my bag. And I'm trying to figure out the object of whomever, what he's speaking of whatever he's speaking of, was a broken glass. And it was a demonstration according to my business. So I wasn't aware that there was residue in it. But I was explaining to him that I was just using it as a demonstration. It wasn't used for to be used at that moment. And at that time, I guess he just wasn't listening, and he called for backup and things in that nature. But I cooperated with them to show them that I wasn't against what was going on. But at the same token, I just got off work. I'm just working and demonstrating my, you know what I mean? So I'm
I'm gonna stop you before you get too deep into it. Because this is being recorded. That is a discussion that you should have with your lawyer, because based upon what it sounds like, this may be something where these charges go away. I have to explain to people a lot of times, everybody who's had their charges dismissed and everybody who's gone to trial and who's been acquitted, they've gone through this process.
Yes, sir.
So you're presumed innocent right here. They should have a body cam that recorded the whole thing, and your lawyer will request that, and your lawyer will review it with the DA's office.
Okay, so I know altogether, how much is the amount for bond?
$4,500.
Okay, and when do I get to speak to a court-appointed lawyer?
I don't know. Which I normally tell people, I don't work for them. Correct. So, and they don't work for me. So I don't control their schedule and they don't control my schedule. But I generally tell people, but today is Wednesday. If you haven't heard from anyone by Friday,
okay,
I would call right now your case. Wait a minute. You were arrested with 3 other people, right?
Correct.
So there's going to be issues related to the case being conflicted out, because the public defender's office can't represent everybody. So each one of you are entitled to your own lawyer. So those lawyers will have to get appointed.
I'll have a letter written up and stated exactly what I wrote and stated to you, except for everybody in the entire and their own lawyers on behalf of me and my business. But at that time, that is for my lawyer and their lawyers, and when we go to court.
Okay.
No problem. And
okay, you're free to go back.
All right.
Mr. Perkins.
Yes.
Mr. Perkins, sir, you're charged with 1 count of misdemeanor shoplifting. Bond is going to be set at $2,000. You're also charged with 1 count of obstruction of a law enforcement officer. Bond is also going to be set at $2,000 for a total bond of $4,000. You're going to have a preliminary hearing date set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. You did not fill out the form, so do you plan on hiring your own lawyer?
I guess.
Okay.
Yeah, I'll plan on hiring my own lawyer.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Are you currently working, Mr. Perkins?
Quit because I'm hearing voices every day. I'm hearing voices. It's been like 2 or 3 years. I've been hearing voices straight.
Okay.
Now
Are you currently taking any medication?
no, because when I was taking it, it made me commit suicide. It made me took all my pills.
Okay. I am going to appoint a lawyer to represent you. And make sure you tell the lawyer what you just told me, okay?
Okay.
All right. You're free to go back.
All right.
Mr. Ross? Mr. Ross, sir, you're charged with 1 count of theft by shoplifting as a misdemeanor, and 1 count of violation of Georgia Controlled Substance Act. That's a felony offense, and you're showing as being either on probation or parole. So I can't set a bond at this time on a felony offense. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for June 3rd at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Why wouldn't you just set it where the county could come get me?
I can't set a bond. It would be against the law for me to set a bond at this hearing on this felony offense, knowing that you're on probation. I can't just follow the law when I want to follow it and don't follow it when I don't.
You could set a bond at the next one?
So yes, the short answer to that is yes. But between now and the next hearing, let's say you talk to your lawyer, you say, hey, look, I want to waive this over to Superior Court, and they can consent. I'll consent to a bond. If they'll consent to a bond, my probation officer come get me and take me back down to Spalding County. So all of that stuff can happen, but you're going to have that discussion with your lawyer.
And you're going to give me a lawyer, possibly?
Yes, sir. I've appointed a lawyer to represent you.
Okay. And I'm going to speak to that lawyer before the court date?
Yes. You're being appointed the public defender's office. And there, I think at least now 5 lawyers that are in rotation for people for preliminary hearings. And so they will, my understanding of their process now is that they schedule appointments to be able to speak to you over the phone.
Okay.
All right. So if you get that notification, accept the appointment offer, because that's something that I've seen as I come into preliminary hearings where they're trying to speak to their client and the client don't want to speak to them. But yes, all of that stuff can happen.
All right.
Okay. Mr. Gerald Wheeler. Mr. Wheeler, sir, you're charged with 1 count of possession of marijuana less than an ounce. That's a misdemeanor offense. Bond is going to be set at $1,500. You're also charged with violation of Georgia Controlled Substance Act, possession of a Schedule II narcotic. I cannot set bond for that offense at this stage pursuant to 1710-1 because there's a showing that you are on parole. And it looks like they're saying that there is a hold on you from the parole board. that they apparently have a warrant for your arrest. And you're charged finally with giving a false name, address, and date of birth, and bond is going to be set at $2,000. Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing set for June 3rd at 8:30 in the morning, courtroom 201. You didn't fill out your form. Does that mean you're going to hire your own lawyer?
Yeah, they're gonna be in.
Okay, do you have any questions of me?
Oh, no, listen, I had a Percocet, and you see my hand right here, I hurt my hand. You see it's still swollen.
Uh-huh.
Like, I don't be carrying around a whole bottle of Percocets. I probably had like 2 Percocets because I wasn't gonna be out that long. So when I got stopped, he asked me what it was. I told him that, you feel me, it's Percocet. And I showed him my prescription over the phone though, and he still charged me with that though. As you see, I hurt my hand in a car wreck, and that's what he prescribed me for. So like, how that work? Like, he still charged me for something that y'all gave me though. The pharmacy gave me that.
Oh, I was gonna say y'all. I'm like, I ain't no doctor.
Y'all work together.
So, Mr. Wheeler, that is something that may lead to this charge being dismissed. However, if you have anything like hydrocodone, Percocet, all of that kind of stuff, keep the pill bottle with you.
I mean, like, I'm not gonna ride around with a bottle full of pills. Like, I wasn't doing it, but going somewhere with my brother to pick somebody up. And
I understand. I'm just saying, if you want to avoid these issues, keep the pill bottle with you. If you want to go through this kind of stuff, don't take it with you. It's your life. You get to live it the way you want to live it. Okay. All right.
So basically you said, I got a bond for all my charges except
for the VGCSA. And because there is a warrant for your arrest from the parole board, if I gave you $1 bond, you're going straight down to Jackson.
Oh no, I hadn't already dealt with it. That's what they going through now. Like, I had that warrant situation going on, but like, they fixing it in the computer. Like my family been in contact with parole, my parole officer right now.
Okay. Anything else, Mr. Wheeler?
Nah, I'm straight.
Okay, you're free to go back. Mr. Jason Wheeler. Mr. Jason Wheeler, sir, you're charged with 1 count of driving a vehicle with no taillights. That's a misdemeanor offense. Bond is going to be set at $500. You're charged with 1 count of theft by receiving stolen property, being a firearm. Bond is set at $2,000, but that was set by schedule. You're charged with possession of firearm by a convicted felon. Denying bond on that charge at this stage. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing set for June 3rd at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Williams. We have Darian Williams. Are you Darian Williams?
Yes, sir.
Sir, you're charged with 1 count of possession of marijuana less than an ounce. This is a misdemeanor offense. Bond is going to be set at $1,500. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail.
All right.
I'm sorry. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
About how much do you make per hour?
I made 18.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. So,
Okay,
so
yes.
Oh, I was just saying, so the bond that you just said, I could just pay that today and probably get out, huh?
Yes, sir. This has been set by schedule, which means it's already in the system. So you theoretically could have bonded out before you even saw me.
Oh, for real?
Yes, sir.
All right.
All right. You're free to go back.
And I'm
Mr. Rayshard Wilson. I'm doing well. Can we cut the crosstalk? Mr. Wilson, sir, you're charged with 1 count of criminal trespass. That's a misdemeanor offense. Bond is set at $3,000. You're also charged with 1 count of aggravated assault. Bond is going to be set at $10,000. There's going to be a stay away provision on the bond to stay away from a Shelley Wilson and a Larry Denham. Do you understand that?
Okay, yes, sir.
Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. What was my total bond again? I'm sorry.
13,000.
13,000. Okay. What I was going to ask you? I talked to my mom and she said that she was trying to talk to someone to get those charges probably dropped because it was like this family dispute.
So she'll need to speak to someone in the DA's office, and it's not necessarily that the charges will get dropped, because I tell people once you bring a third party in, that third party now has to make a decision about your life. If it's just a family dispute, the police shouldn't be called. And I'll tell you why. At the time that the police are at your house, there was someone that had a gun stuck in their face, and they really need that officer to be with them rather than at your house.
Yes, sir.
Okay. Any other questions?
No, sir.
Okay, you're free to go back. Mr. Yarborough.
Yes, sir.
Mr. Yarborough, sir, you're charged with 1 count of aggravated assault. Bond is going to be denied at this time on this offense. There's going to be a stay away provision on this bond to stay away from a Marcus Owens. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning. You're going to have a bond hearing date set for June 3rd at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Grayer.
Yes, sir.
Mr. Grayer, sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $4,000. There's going to be a stay away provision on this bond to stay away from a Gloria Okohensi. Do you understand that?
Yes, sir. That's my mother.
I understand. But she's also the alleged victim in this case.
No, she's not the victim. Shh. Don't argue with it.
Okay.
So I'm telling the truth. I just got. Did you get a police report? Did you read the police report?
Mr. Grayer, I want you to listen, okay?
Yes, sir. It was regarding with apartments, not my mother, sir. My mother, no, I mean, I never got a police report. I'm not even in the system at this jail, sir.
Mr. Grayer, you said you're gonna listen and then you started talking. All right. So it says that you committed the offense of criminal trespass when you got in an argument with Gloria Okohensi. The victim walked in her room and closed the door to avoid you. Said you used your foot to kick the door in, causing damage to the door less than $500. So the allegation of criminal trespass is that you kicked in her door, causing damage to her door. And that's where criminal trespass comes from. So you're going to have to stay away from her. If you do not, you're going to get charged with aggravated stalking, which is a felony offense. Your bond will be revoked and you will remain in jail until your trial. You're going to have a preliminary hearing date of May 31st at 8:30 in the morning, courtroom 201. I am going to appoint a lawyer to represent you. And unless he has any questions related to these charges, he is free to go back.
Yes, I have.
Yes, sir.
Can you hear me, sir?
Yes, sir.
I have a question like so as soon as what if I'm not able to afford the bond, so I'm not working anything right now? Is there any way I can talk to a lawyer to get probation or anything?
I've appointed you a lawyer, and you will be able to speak to that lawyer. And depending on the facts and circumstances of your case, these charges may be dismissed or it may go to trial. I don't know, but that's where the lawyer comes in.
Yes, sir.
All right. You go back, Mr. Greer.
Thank you.
You're welcome. Okay, so that completes the calendar. I'm going to do the continuance orders for those two young ladies, and we'll just make certain they come back tomorrow.
Yes, Your Honor.
Thank you. Have a good day.
You too.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
What is your name, sir? Good.
Leonard Echeverria, boss.
I'm
Your
sorry.
Honor, Your Honor, I'm sorry.
Okay, hold on. Just tell me your name.
Leonard Echeverria, sorry about that.
Okay, that's okay. Make sure I got all the right papers here. Hold on.
Oh, wait, did we skip somebody?
Well, I had the next one as Samuel DeJesus,
Oh,
but
yeah, he bonded, I'm sorry.
he bonded. Oh, okay. Well, I need that one. All right, sir. You have been arrested on a charge of driving while license suspended with 2 prior convictions for that offense. I found probable cause as to that offense. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. I've examined your affidavit, and I find that you qualify, so the public defender will be appointed. You also are presently out on bond on 2 cases involving driving while license suspended. One is 2019 CT 1731 in Osceola County. The other is 2019 CT 12. Looks like, I don't know if that's a 3 or a 5. It looks like 3-4. 1, 2, 3, 4. 1, 2, 3, 4. In Osceola County, you made bond on both of those cases, $500 on one and $3,000 on the other. So.
May I be heard? Don't say anything.
No, I didn't.
Don't say anything. Yes.
Sorry about that.
Without litigating the facts too much, this may be able to give an indication. The accused has informed me that his wife is currently in labor, and this current thing may have been an emergency. So if the court is inclined to revoke his bond, we'd at least ask that you don't set it at 0 and you set a new bond amount so that he could be there for the birth of his child.
She's 4 centimeters right now.
I don't see anything in this about.
Well, of course, the officer's not going to ask why.
Yeah, he just,
Well, but if there's a visibly pregnant woman in the car, generally most officers, I think, would.
He didn't even.
You'd be surprised how much police officers leave out there.
Well, I'll be honest with you.
Yeah. I know it doesn't look great.
Since this is the 3rd offense,
I know, sir.
I'm afraid you're going to have to stay in jail. I'm going to revoke bond on the other 2 cases. And I'm going to set the bond on this new case at $5,000 since the last one was $3,000. And we're going to keep you off the road one way or the other.
All right, so.
If what you said to me is true, congratulations.
No, we can call right now, sir, I promise you.
No, that's okay.
No, because I'm nervous, like, I don't want to miss the birth. I'm sorry.
I hope it's true, and I wish you the best.
Thank you, sir.
And your child will much appreciate you getting this straightened out.
She will.
All right, thank you.
Sir.
Sir, please tell me your name.
Timothy Gomez.
All right, sir, you have been charged with the offense of grand theft, third degree of a motor vehicle. I find probable cause in that case. Your bond is set at $1,000. Would you like the public defender appointed?
Yes, sir. Yes, sir.
All right, then we'll let me look at your affidavit. All right. Yep, the public defender will be appointed to represent the defendant. The bond on that case is presently $1,000. You are presently out on bond on, oh my goodness, look at that, grand theft, third degree of a motor vehicle.
No information has been filed in that case yet, Your Honor.
What is going on? Sorry. Promised myself I wouldn't see. Can you give me more information about the other case, whether it's anything?
I also see that we have, I'm sorry, that we have not filed anything. I can check to see when.
When was the arrest date was 5/2?
Yes, Your Honor.
Okay. Well, here's what I'm going to do. I'm going to go ahead and revoke bond on the old case. Obviously, if the charges are not filed within the next 3 or 4 days, he'll get out. If they are, then he probably shouldn't be out. And I'm going to stay the bond on the new case of $1,000. So what that means, sir, is that if the state doesn't file the old case, then your whole bond is $1,000.
Yeah, I know.
And if they do, then you're going to sit in jail until the judge in that case decides to let you out.
Yes, sir.
All right? All right. Sir, what's your name?
Larry Harmon.
All right, Mr. Harmon. Your name is familiar to me. Have you ever been involved in a case I was involved in? No?
I think the last time I was.
Come on, Judge.
No, he could be a victim or a witness or a victim's family or something. Never mind.
Guess the last time I was here.
Why are you so sensitive?
I'm just trying to protect my client.
No, I understand. I understand that. Well, actually, I was a prosecutor for a long time. And so, sometimes that's how I may know you. Anyway, you've been arrested for the crime of grand theft of a motor vehicle. And I have examined the arrest affidavit, and I do find probable cause for that charge. Your bond is presently set at $2,500. You do not qualify for pretrial release. Would you like the public defender appointed?
Yes. Yes.
All right, we will appoint the public defender to represent you. You also have a hold out of Seminole County. So if you were to make bond here, I guess they'll just send you up to Seminole County. But your bond here is $2,500. And unless I hear argument from anybody else, I'm going to stay at $2,500. All right.
No.
I'm sorry.
Mr. Harmon wants to know if the court would be inclined to reduce it to $1,500.
On what, for what reason?
He is indicating to me that he has children at home and he wants to be able to save as much before he can go back.
State?
The state would note that there are 3 prior FTAs, as well as it looks like several convictions. So the state would request that the bond be stayed.
Yeah, I'm going to save the bond where it is. And I just want to say to you, if I knew him as a defendant, he would be in prison right now.
That's true.
Okay, so then it's no.
I mean, but you were the elected state attorney up until 2016.
That's true.
So, like, technically, all of the cases were your cases.
I didn't mean it that way. Thank you, sir.
All right, thank you. I guess what you meant, like, if you personally handled the case.
No,
you
no,
would
his
be-
name just sounded familiar. And,
All right.
Okay, sir, what's your name?
A.B. Harold.
Okay. And sir, you have been charged, ooh, excuse me, with, oh my goodness. Oh, goodness me. You've been charged with retail theft under $300. I've read, oh, this is a warrant, so you were arrested on a warrant. A judge had found probable cause that you committed that offense. I think there's actually a number of them. In 2019 CF 31, what is that? I'm sorry. In 19 CF 7315, you're arrested on a warrant for retail theft. The judge having found probable cause. In that case, the bond was set at $1,000. Is that the same one? Yeah, that's the same one. In case 2019 CF 7278, you were arrested on a warrant for retail theft under $300. The bond on that case was set at $1,000. In case, is this the same? Did I already say 6945?
No, you did not, Your Honor.
Okay. In case 2019 6945, you were arrested on an arrest warrant for grand theft third degree, value between $300,000 and $5,000. There's a $1,000 bond in that case. In 19 CF 6771, you were arrested on a warrant for grand theft third degree. Amount of bond is $1,000. I think that's all of them. I think I got them all there, yeah. Would you like to have the public defender appointed to represent you? If that, you're nodding yes.
Yeah, yes.
Okay. The court will appoint the public defender to represent you in all of these cases. I also note that you are presently out on bond on 2019 CT 2397, 19 CT 2398, 2019 CF 1447, 2019 CF 2150, 2019 CF 2188, and 2017 CF 13183.
Your Honor, may I be heard?
Please don't tell me the 2017 case hasn't been filed yet.
No, that's actually not what I was going to tell you. I was going to tell you that he's been adjudicated incompetent to proceed in a majority of these cases. I have one confirmation so far. I didn't confirm. This is what PTR told me. I just confirmed the 2017 case. He was adjudicated incompetent to proceed on January 25th, 2019. So at this point, he's presumed incompetent to proceed and cannot be held.
I'm sorry, what did you just say?
I said, so he was adjudicated incompetent to proceed on January 25th, 2019 in the 2017 CF case. I haven't verified the other cases at this point, but right now he's presumed incompetent to proceed. I don't know whether or not you can modify the bonds that were set in the warrant, but I would just ask that you take no action on these since he is incompetent to proceed and the court has no choice. I have the case law, I just have to pull it up. The court has no choice but to keep him on conditional release. The legislature hasn't provided a...
Is he on conditional release or on bond? Because these say he's on
He would be on
bond.
conditional release because he was adjudicated incompetent to proceed. So that would put him on conditional release. Any bond would be... He might have bonded out at one point, but then he would have been placed on conditional release once he was adjudicated incompetent to proceed.
Well, what I'm going to do is I'm going to revoke the surety bonds that were issued on any of these cases. There's one where it doesn't really, none of the boxes are checked as to how he is out. So that's I'm going to do that on those cases. Any in which a bond was set, the bond is revoked. Obviously, if he's on conditional release, that's not subject to that ruling. And the bond amount on the existing cases will be maintained as, and on the old cases where I'm revoking the surety bonds, the new bond is no bond.
Okay.
Okay?
I'll have your attorney address it. Okay.
Okay.
No, I will have I will contact your attorney and have them address it.
I can't bond out.
No, sir. Can't bond out.
I think they just haven't adopted the findings in his 2019 case, his 29 CT case.
Yeah.
That's all. Because the way the new procedure works is that they handle it in circuit court, and then they send that ruling down to the county court cases, because county court cases get stayed. So they just haven't adopted the finding yet in the 2019 case.
Yeah.
We don't have a good system of dealing with those things. All right. Your name, sir?
Stefan Lilly.
What is it?
Stefan Lilly.
Oh, okay. Well, that's the next one I had in my pile was Javette Laponte.
She's mental health, Your Honor.
Oh, okay.
We just asked that you be reset for tomorrow.
Mental health.
Okay, so this should be reset for tomorrow?
Please.
Okay, just, I had determined, this is for the state's benefit, what? Wait a minute, oh, that's the old one. I did not find probable cause for burglary of a conveyance, only for trespass.
On the point?
On the point,
Okay.
yeah. I only find PC for trespass, not burglary, so take a look at it if they want to try to supplement it by tomorrow. It didn't seem like a burglary to me, but, so that'll be recalled tomorrow. Okay. Sir, you have been arrested on charges of possession of methamphetamine and possession of drug paraphernalia. I've looked at the arrest affidavit, and I find probable cause for both. Would you like to have the public defender appointed to represent you?
Yes.
All right, we'll appoint the public defender based on your application, and the public defender will be appointed. Your bonds at present are $2,500 on the possession of methamphetamine charge and $100 on possession of drug paraphernalia. All right, moving on. This would be, yes, sir, can you?
Ayub Rafiq Manraj.
Manraj, Mr. Manraj, you are charged with aggravated assault with a deadly weapon. In this case, I do find probable cause for those offenses. Based on your affidavit, you do not qualify for the appointment of the public defender, so you have the right to hire your own attorney for these charges when they come up. At present, you're being held on no bond on aggravated assault with a firearm. State, I believe I am required to set bond in this matter because it's not a life felony. I don't believe there's been any motion for pretrial detention filed. Is that correct?
That's correct, Your Honor.
All right. Would you like to be heard on the amount of bond?
Your Honor, if I may have a moment. Your Honor, the bond schedule I'm looking at just says that it must be set by the judge at the first appearance. I do note that there are no prior, or there is a prior, a DUI, but other than that, no other history. Though reading the affidavit, the state would request at least a $5,000 bond.
Sir, can you tell me a little bit about your finances? What do you do for a living?
Auto body tech.
Auto body? All right, and you make about $500 a week?
Yes, Your Honor.
Okay. Do you own your own home?
I'm paying for it.
But I mean, you're the owner, you like pay a mortgage?
Yeah.
Okay. Do you know how much your house is worth?
Probably 140.
How long have you had the house?
2009.
Since 2009, so about 10 years?
Yes.
Okay. Do you know what the equity in your house is?
I'm not sure.
Do you know how much you owe?
I think maybe 40-something thousand.
Okay. So it sounds like you have a pretty good amount of equity in your house. All right, sir. I am going to set bond in this case at $5,000, $2,500 on each count. So that means you're going to have to come up with, you should be able to come up with $500, and then the rest would be security in your house. You cannot, during the period of your release, own any weapons or simulated weapons. Okay? You can't have a BB gun, you can't have a squirt gun, you can't have a gun or anything that looks like a gun in your possession. All right? If you have some in your house, give them to somebody else. You also cannot have any contact with the victims in this case. And I know this is a neighborhood area, but you can't talk to them, you can't look at them, you can't say anything to them at all, or to their parents or any member of their family that you know of. All right?
Yes, sir.
Any other conditions the state's requesting?
None, Judge.
All right, so that'll be the resolution of that case. Thank you, sir.
No, you'll get it.
All right, sir, please tell me your name.
Joshua McNeil.
All right, Mr. McNeil, you've been charged with the crime of burglary of a conveyance. I've looked at the arrest affidavit, and I do find probable cause for that offense. Would you like to have the public defender appointed to represent you?
Yes, Your Honor.
All right, public defender will be appointed. Your bond is set at $3,500 on the single count of burglary of conveyance. There is a second case. See, I'm getting better at this now, aren't I? There is a second case in which you have been charged with 2 counts of burglary of a conveyance. The court will appoint the public defender on that case as well. I've looked at the arrest affidavit, and I find probable cause on that as well. Your bond on that case, on count 1, is $3,500, and count 2 is $150. So the total bond in both matters is $7,150. All right, you understand?
Yes, sir.
Okay. Anything from any counsel? No, no? All right, very good then. Thank you. All right, sir, please tell me your name.
Ronald Christopher Olson.
Okay. I had in the next one Mr. Negron. Is that not coming
He
up?
wasn't on our court list.
Sorry?
I don't have that either.
Who?
I have it.
Here, you can find it faster than I can.
Might be somewhere else in there, or?
5880.
I got a special present. See, I got one you didn't.
Oh, he bonded?
He bonded.
Okay, that's fine.
Figured something like that. All right, Mr. Olson, you have been charged in this case with multiple offenses, trafficking in heroin, possession of cocaine, possession of OxyContin, possession of alprazolam, possession of a controlled substance, 2 counts of that, and 1 count of possession of drug paraphernalia. I do find probable cause as to each of those offenses. Sir, would you like the public defender appointed to represent you?
Sure.
Okay. Your enthusiasm is noted. It's been a long day for both. So based on your financial affidavit, I appoint the public defender to represent you. Your bond in this case is on count one, $100,000. On count two, $1,000. In fact, on counts 3 through 6, it's $1,000 each count, and $500 on count number 7.
What was the last one? I'm sorry, Your Honor.
Sorry, what?
What was the last bond count for count
500.
500?
500. Anything from either counsel? Nope. All right, sir. Thank you very much.
We would just ask that you reduce the bond on the first count. He's never failed to appear in court. He only has 5 misdemeanor convictions and 2 felonies. It says you got 2 here. So we'd at least reduce it to $50,000 or less.
Sir, you got any money?
I might be able to come up with some, but I can't come up with that.
Okay. Do you own any real estate?
No.
Okay. Do you own any expensive jewelry?
Nope.
Any? Do you have a car?
I do.
What kind of car?
It's 89 F-250.
All right. That's a classic. Do you have? Where would you get money to make bond from?
Probably from my parents or something.
Yeah. I think that in order to lower the bond on this, the court should make a very thoroughgoing examination of the source of any funds. And we don't have the resources to do that right now, so I'm going to stay the bond as it is. But the trial judge can look at that later and have a more thorough examination of it. Okay, yes, sir. What's your name?
Norman Perez, Your Honor.
Okay. Okay, so I had a Mr. Paul Bonded. Okay. Hold on. These don't seem to be in the order that those other ones were. Well. Okay. Yes, sir. You are charged with fleeing, attempting to elude a police officer. I have looked at the arrest affidavit in this case, and I do find probable cause in the matter. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. Based on your information in your application, the public defender will be appointed. Your bond is set at no bond. Counsel like to be heard on that?
Yes, Your Honor. Mr. Perez Morales is entitled to a bond at this point. The only reason it's no bond is because by statute, the IA judge is supposed to set a bond on this type of charge. It's no bond until you see an IA judge. But it's just like the DV cases. We would just ask that you set a reasonable bond amount.
All right. And state?
State has no objection to setting a monetary bond, just noting that there is an extensive history, it looks like.
Yes, I'm trying to, these are, I take an hour. They're not in the same order. Everything else has been in perfect order, but those are not in the right order. I don't know. Anyway, what is the history that you have?
I've got 11 felonies, 3 misdemeanors, including use of a false name on a driver's license, operating a motor vehicle without a valid license, stealing and stolen property, false owner info, pawn items, dealing and stolen property, VOPs, burglary, petty theft, 2 priors, resisting recovery of property.
Sir, what financial resources do you have?
They're real low, Your Honor.
Okay. Well, based on your record, I'm not comfortable with setting a bond anywhere below $5,000 because I don't know enough about your finances, and with that record, the likelihood of your not appearing is fairly high, so you need to have a lot of skin in the game. So I'm going to set the bond at $5,000 on that offense. And did I appoint the public defender?
I think you did.
I didn't yet?
Yes,
I did.
Judge.
Okay, I thought I did, but sometimes you do it over and over again, you forget. All right. There it is. Here they were.
They're not gonna deal with it right now. Yeah, just go ahead. Yeah.
All right, sir. Your name?
Petty?
All right, Donald Petty?
Yes, sir.
All right. On this case, you were charged with burglary of a dwelling and trespass in a dwelling after warning. I found probable cause on count 2, but I don't find probable cause on count 1 on the burglary count. I don't see anything here indicating intention to commit a crime within the dwelling. So do you want 24 hours to try to?
Yes, please, Your Honor.
All right. So we'll grant the state 24 hours to try and supplement the affidavit. So we may see you tomorrow morning. Right now, your bond is set at $5,000 on count 1 and $150 on count 2. You could bond out, right now if you want. Tomorrow, based on what I find, that bond amount might go down.
I have one thing to say, sir,
Sure.
if it's okay.
Yeah, you probably don't want to tell me about the facts of the case. We'll talk more tomorrow. Do you want to have the public defender appointed?
Google search my name, sir, please.
Well, don't Google search mine.
I'm not. I'm
No.
just letting you know, sir, I've fought this. This is my second time in this courtroom for the same thing.
Okay.
The state of Florida dropped my charges because the house was in my name. You're not
Okay.
allowed to steal land, and that's what the man has done again. He pulled up with 2
Okay.
officers, told me he stole my house.
Okay. Okay, well, we'll hold off on appointing public defender until next time. All right, can you tell me your name?
Lyrical Preston.
All right, you have been charged by warrant with aggravated battery on a law enforcement officer with a motor vehicle, fleeing and attempting to elude a law enforcement officer with lights and sirens, and resisting an officer with violence. This is a warrant. Probable cause has already been determined. You do not qualify for appointment of the public defender, so you'll have to hire your own attorney. At present, your bond is set at $10,000 on the aggravated battery and no bond on the fleeing and eluding until you see the judge that issued the warrant. And on the resisting an officer, it's $1,000. Thank you.
Okay, so what does this mean?
Pardon? Count 2 is still no bond. Yeah, that's in the warrant. Warrant's in no bond. So.
Would the court mind repeating the bond for Ms.
Sure.
Preston?
Just the total bond.
The bond on count 1 is $10,000.
Yes.
The bond on count 2 is no bond until till you see the judge that issued the warrant. And the bond on count 3 is $1,000. So you can't bond out until you see the judge that issued the warrant.
Wait, they didn't put an amount on here?
It just says no bond.
It can be modified. She's entitled to a bond. This is a non-capital or punishable by life offense.
This is my first.
Well, it's a
And
warrant, though.
I understand, so the warrant establishes probable cause, but you can modify it unless the judge in the warrant says that you can't.
Well, let's see what it says. Oh, let's see.
Yeah, it says at the bottom, may be modified by first appearance judge.
Oh, so it does. So it does.
So I would argue that she's entitled to a bond on the fleeing and eluding since it's non-punishable by life and capital offense.
Sure. State, you want to be heard?
State would just note that, it's screened for out on bond in Orange, Osceola, but she has the warrant pickup in Miami-Dade that she's on.
I'll set bond on count 2 at $1,000. All right.
Thank you, Your Honor.
Thank you. Your name, sir?
Anthony Ricks.
Okay, you didn't look like Patricia Rashid, so.
She's in the hospital, Your Honor.
She's in the hospital?
Yes.
Okay, so call that back up tomorrow. Mr. Ricks, you have been arrested on, let me see, I think this is multiple cases here. Long one. Yeah, 2 cases. The first charge is robbery with a firearm, and that, I've examined the arrest affidavit in that case, and I find that there is probable cause shown. Also, in the second case, you are also charged with robbery with a firearm. I've examined that arrest affidavit and do find probable cause is shown. Would you like to have the court consider appointing you a public defender?
Yes.
All right, I have your application in front of me, and I do appoint the public defender to represent you. At this point, you are being held on no bond on each of these 2 cases. Anything from either counsel? All right, thank you, that's all we have. Bonds will be stayed. Your name, sir?
Andrew South.
All right, Mr. South, you have been arrested on a charge of petty theft in the 2nd degree, 3rd or subsequent offense. I've examined the arrest affidavit, and I do find that probable cause is shown. Would you like the court to consider appointing the public defender?
Yes, sir.
Based on your affidavit, you qualify, so we will appoint the public defender to represent you. At present, your bond is $1,000. Thank you, sir.
Okay.
All right. Your name, sir?
Palmer Stuckey.
Mr. Stuckey, you are charged with 4 counts. The first is possession of MDMA or ecstasy. The second is possession of cannabis with intent to sell. Third is resisting officer without violence. And the fourth is possession of cannabis. I find probable cause based on the arrest affidavit on all 4. Would you like the court to consider the appointment of the public defender?
Yes, sir.
All right, based on your affidavit, the public defender will be appointed. Your bond on count 1, possession of MDMA, is $15,000. Your bond on count 2 is $150. Count 3 is $100, and count 4 is $100 as well. So that's a total of $350 is a total bond.
Your Honor, Mr. Stuckey would like me to ask for a bond reduction. I'll let the court take test. What would you like to tell him? Why?
I was just asking because on the first count is 15,000. The second one is 500. I mean, 150.
He reduced those.
Oh, you reduced those. Oh, but it's just 15,000. I don't have that time. I just recently, lost my job, so it's like, I'm just making the ends meet off those last 2 checks, I made, and I pay rent with that too, so.
Yeah.
And 15,000, a little steep, 10% of that is 1,500, but with all these, it'll be 1,800 in total, and 1,800 is a little steep right now,
Well, I'm going to deny your request now, but that doesn't mean you can't bring it up in front of the trial judge in the case. He'll have more information, have more time to do a more complete hearing, and the public defender's office will have a chance to put a presentation on. But at this point, I'm going to leave it right where it is.
All right.
Bond will be stayed.
So when
She's gonna come today.
Mr. Bryant?
Yes, sir.
All right. You have been arrested on a failure to appear on a possession of cocaine case. The court has ordered your arrest and that you be held on no bond. The court also has I guess this is a new case, involving 3 counts of burglary of a conveyance and 1 count of grand theft. The court has examined the arrest affidavit in the case and does find probable cause. Would you like to have the public defender appointed in the new case?
Yes, I would.
All right, based on your application, the court will appoint the public defender in that case. Your bond on the failure to appear is no bond until you see the judge. Your bond on the new cases is $3,500 on count 1 and $150 on the other 3 counts. That bond will be stayed unless there's any motion to do otherwise, and you'll be in jail until you see the judge on the case you failed to appear on. All right? There you go. All right. Sir, your name?
Jeremy Tillman, sir.
All right, Mr. Tillman, you have been arrested on a count, well, actually a number of counts. You've been arrested on 15 counts. Grand theft, possession of a firearm by a convicted felon, possession of heroin, possession of methamphetamine, and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 counts of possession of ammunition by a convicted felon, and the last count is possession of cannabis. I find probable cause for each of these offenses, though I'm going to only set a bond on one of the possession of ammunition charges and RR on the rest, because I'm not sure ultimately you can be charged with every bullet that was found.
Yes, sir.
But I do find probable cause for the rest of it. Would you like the court to consider appointment of the public defender?
Yes, sir.
All right, based on your financial affidavit, the court will appoint the public defender to represent you. Your bonds in this case are as follows. Count 1 is $150, count 2 is $150, count 3, possession of heroin with a weapon, is $15,000. Possession of meth is $150. Possession of ammunition is $150. All of the other possession of ammunition cases will be changed from $150 to ROR. And on the last count is possession of cannabis, and that is $100.
Yes, sir.
All the bonds will be stayed with the exception of the possession of ammunition counts. The repetitious ones will be ROR. Anything else? All right.
One for you, that's why, because those other ones were originally higher, so he reduced them for you.
Thank you, Your Honor.
Thank you. All right. Are you Mr. Turner?
Jordan Turner.
All right, sir. You have been arrested on a charge of retail theft. I find probable cause exists in the arrest affidavit. Would you like the public defender to be appointed?
Yes, sir.
All right, the court will appoint the public defender based on your application. Your bond on the retail theft count is $1,000. You also are presently on bond on 2018 CT 1237, driving while license suspended or revoked with knowledge. Oh, wow, has that actually been, is it a traffic citation?
Yeah, it's a citation, so I can't argue that it hasn't been filed on in good faith, because an NTA is a charging document.
Nice for a change. All right, so I'm going to,
I would ask you take no action on it since the 2 cases are unrelated.
yeah, I'm going to do that.
Thank you.
So your bond will remain as $1,000 on that. Now, that doesn't mean that the trial judge can't revoke your bond.
It's okay.
Based on that issue, so. All right. All right, your name?
Shanika Turner.
All right, Ms. Turner, you have been arrested on a charge of retail theft of under $300. I do find probable cause for that case. Would you like to have the public defender appointed to represent you in this matter?
Yes.
All right, based on your application, I will appoint the public defender. I also note that you're presently on, well, let's see, it says competency hearing.
She's been adjudicated incompetent to proceed in that case on October 1st, 2018.
In
So
both
she's
of
on
them?
conditional release.
Okay.
I didn't check the 2017 CF, but the 2018 CF case, okay.
Yeah.
So at this point, she's presumed incompetent, so I'd ask that you reduce the bond in the new case as well.
Well, State?
Your Honor, I don't see the adjudication for the motion of incompetency, though.
Are you in the new case or the old case?
18 CF.
I mean, my note says competency hearing.
Right, that's
which
what I have.
might imply that it was set for hearing but not yet determined,
Let
but,
me double check, but when I looked it up at the beginning of this morning, it said they were adjudicated on October 1st of 2018.
that's very possible.
Because they could have statuses, because that's what they're supposed to do.
Yeah, that could be.
I go every other month to court.
She says she goes to statuses every other month.
Yeah, every six.
I see that there was a second evaluation, but I don't see the order.
It's right here.
So that's the competency order?
It was just handed me by PTR, I'll pass it around.
Okay, no, it's all right. Well, I don't need to see it. So I won't take any action on the existing cases because they don't indicate anything that would, it's inconsistent with it being found incompetent. But I'm not going to alter the bond on this case. I'm going to leave it at $1,000 bond. Basically because this is so similar to the other crimes. This is different, right? Different. All right. Please tell me your name.
Teresia Turner.
All right. You were arrested on possession of controlled substance and possession of cannabis. I find probable cause as to both.
Oh, sorry, I didn't.
So no, I'm just looking.
Oh.
So you came to BRC to see somebody and you stayed?
I came to.
Don't say anything. Don't say anything. I'm just pointing out the irony of life. Okay, I find probable cause as to both of those. I note that you also are on bond on a battery case, 19 MM 3565.
Yes, Your Honor.
Yes, Judge.
All right. Does the state want to be, well, the bonds on this case, on possession of controlled substance is $1,000 and possession of cannabis is $100. I'm going to stay the bonds on those two, so that will be your bond. Does anybody want to be heard on the existing cases?
No information's been filed.
State would just request that it be revoked.
Well, if the information hasn't been filed, then I'm not going to revoke it.
Yes, that's correct, Judge.
All right. All right, thank you. Okay. Sir, your name, please.
Michael Valadez.
All right, Mr. Valdez, you have been arrested on charges of grand theft, third degree of a motor vehicle, possession of alprazolam, and possession of cannabis. Court finds probable cause as to all of them. Would you like the public defender appointed to represent you?
Yes.
Yes? Did you say yes?
Yeah.
Okay. Based on your affidavit, I will appoint the public defender. In this case, your bonds on these charges are $2,500 on grand theft, $150 on possession of alprazolam, and $100 on possession of cannabis. You also are on bond on a charge of grand theft of a motor vehicle in 19 CF 6282. On the new cases, the bond will be stayed.
No information's been filed in that other case, so we'd ask you take no action. They're just slow with making their filing decisions.
Well, I would note the arrest just happened this month, so.
And this 33rd day is coming up.
I'm going to put a paperclip over my lips just so I don't say anything. Okay, anyway, so I'm not going to take any action on the existing case. The bonds will be stayed on the new case. And did I ask you if you wanted a public defender?
You should.
Oh, good. I'm getting a little bleary here.
I'm good.
Yep, you can go.
All right, please tell me your name.
Hector Morales.
Okay. Okay. The next one I had was Gerald Watson. Is
He
that?
bonded, Your Honor.
He bonded. That's good news. I wish more people would follow that. Oh my God. I'm just standing up to stretch. All right, sir. You have been arrested on capiases for failure to appear. Those capiases were issued by the judge. He or she set the bonds at $250 on count 1 and $500 on count 2. That is all, that's all we need to discuss. He has another. Oh, never mind. Spoke too soon. Oh, there it is. Oh my gosh.
I had 3 counts. Is there another?
Oh yeah,
case?
there's a third, possession of cannabis. It's a separate affidavit. And the bond in that is set as $500. So if my math is correct, your total bond is $1,250. All right. Okay. All right. Your name, sir?
Frankie De Hoyos.
Okay, so I had a Charles Davis.
He bonded, Your Honor.
Bonded out. Music to my ears. Of course, I had to read this silly thing. Could have done it before I read it, right? Maybe. Anyway, okay, sir, you have been charged. I think we have 2 cases. The first is a driving while license suspended charge. I have read the arrest affidavit and find probable cause on that case. Your bond is set at $500. Would you like to have the public defender appointed in that case? I'm sorry, was that yes?
So you gotta say it.
Yes.
Yes, all right. Based on your affidavit, the public defender will be appointed, and the bond is set at $500, and that bond will be stayed. We have another violation of probation affidavit. This is from another county. Judge issued a order for your arrest, and I'm trying to think of what county this is, but
It was Lake County, but he was being supervised by Orange County.
okay. Well, so you'll be going back to Lake County, and I believe that is no bond. So you won't be getting a bond until you go and see the judge in Lake County.
When will I be able to go to Lake County?
I don't know.
They'll come pick you up.
Yeah, once your Orange County case is satisfied, then they'll send you to Lake County to take care of that.
And when you mean by satisfied, what does that mean?
Well, when you it gets dropped, you plea, your lawyer can talk about it later.
When the case is over.
Can I just pay the bond?
Okay, so
You
you
won't
got
be able to
both.
get out and you won't get time, so don't pay the bond.
I won't get any time?
Yes, because the thing is, if you pay that bond right now, you're not going anywhere, and then you'll stop gaining time on that case, so don't bond out.
All right. Sir, what is your name?
Edwin Bellamy.
I'm sorry?
Edwin J. Bellamy.
Okay, I had a Victor
He bonded, Your Honor.
Lescanzo Bedoya.
He bonded.
I know, but I want to pronounce the name. I want to show that I can do it. All right. Let's see. Okay. Mr. Bellamy, you are charged with, let's see, is this the, this isn't the ones that are.
He bonded too.
In this case, you are charged with trespass in a dwelling. I have examined the arrest affidavit. I do find probable cause. Would you like the court to consider appointing the public defender to represent you?
Yes.
All right. Based on the affidavit, the court will appoint the public defender. Your bond at this point is set at $500.
You wanted to know if you could resolve this case today?
State?
There's no offer from the state at this point, so it'd just be to the bench.
Well, you can, you know, I'm going to say no. I mean, I'll take your plea now, but I won't sentence you now because your victim, the victim of this case, has a right to be here to speak. So if you want to enter a plea today, I can, but I won't sentence you. So I'm not sure you want to do that.
No, Your Honor, he doesn't want to resolve this case.
Okay, very good.
Been trespassed, so.
That's okay.
There you go. Okay, Mr. Murillo Martinez.
Tony Jackson.
Tony Jackson.
That's who I have too.
Murillo wasn't on our court list.
Okay, well, let's see. What do we
Mine
got here?
either. He must have bonded.
This, Well, I have a whole bunch of stuff here, and hold on. What's going on here? I've got a whole. I've got Marilla Martinez. I've got Jesse Morris, David Skelly.
Jesse Morris bonded, Your Honor.
Okay, so Jesse Morris bonded. That one's out.
Skilly is mental health, Your Honor.
Skelly's mental health. Marilla Martinez. We don't have that anywhere.
No, what's the inmate's number?
Here, you'll have to. Your eyes are getting blurry.
1901-5887.
Bonded?
Yes, sir.
All right, good news. Jamal Tapper?
She's on the wall. I mean, he's on the wall back here.
He's on the wall back there, okay. And Catherine Todd?
She's on the wall.
Catherine Todd. And what was your name, sir?
Tony Jackson.
Tony Jackson. Well, I'm gonna have to dig for you a little bit here, hold on. Oh, it was the one that was, attached to something else? Oh, okay. All right, now we got you. All right, so, sir, you've been arrested for the offense of simple trespass. Let me just take a look at this. All right, you're charged with trespass after warning for sleeping under I-4 after you've been told not to. I do find probable cause that offense occurred. Would you like the public defender appointed?
Yes, sir. Could I resolve today too?
Absolutely. What, you want to plead?
Yes, sir. I'd like to plead if
All
I
right.
could today.
The victim's the city of Orlando, so I don't know if you would, I don't know if they're actually considered like a personal victim.
Well, that's up to him. I mean,
No, I was just saying
Yeah.
for like, I didn't want it to be like the last situation where
yeah.
they plea and then they don't, it's a,
Okay.
you understand?
Yes. The charge against you is that you slept under I-4 at Amelia and Garland after you were told by law enforcement officers you were given a trespass warning on January 8th, 2019, not to go to that area, and then you were back there on May 24th, 2019. Do you understand that those are the facts that have been alleged in this?
Yes, sir, I do.
All right. And do you wish to enter a plea of guilty?
Yes, sir, I do.
Do you understand you have the right to an attorney or to have an attorney appointed to represent you in this case?
Yes, sir, I do.
All right, do you waive the right to have an attorney appointed?
Yes, yes.
Do you understand you have the right to trial by jury on this matter and to have a group of citizens decide whether you're guilty or not?
Yes, sir, I do.
And do you waive that as well?
Yes, sir, I do.
All right. I'm going to find that you've entered a voluntary and intelligent plea. If you are not a U.S. citizen, it's possible that this offense might result in your deportation. Do you understand that?
Yes, sir.
All right. I will accept your plea of guilty. I'm going to sentence you. Here's what, 1 day time served? What time? I'm just going to sentence him to time served. Huh? 2 days. 2 days. Okay, you're adjudicated guilty, sentenced to 2 days time served, and just find someplace else.
Yes, sir.
Or maybe one of the shelters will have some room for you.
Thank you, sir.
Thank you.
Have a good weekend.
You too. All right. Okay, so what was this? Oh, this is the ones I'm going to. All right. And your name, sir?
Jamal Tapper.
All right, Mr. Tapper, you have been arrested on a charge of possession of cannabis and possession of drug paraphernalia. I've examined the arrest affidavit, and I do find probable cause for both of those offenses. Would you like the public defender appointed?
No.
No? Okay, that's fine. Your bond on each of those charges, the first count is $100. The second count is $500. So you can be released on bond. I don't have my PTR sheets in any kind of order here. Is he eligible for PTR?
He is out.
He's out on, oh, that's right, I have it right here.
It's an NTA for voting.
For no wake zone.
Bad timing.
I just, you're a John Dillinger, you know, around, sorry, can't take it seriously. I'm going to take no action on the no wake zone offense, and your bond will be stayed as indicated on, you know, yeah, the bonds will be stayed. Okay, so, there you go. Do you want the public defender appointed?
I have a lawyer. I just couldn't get in contact
Good.
with him.
Okay, well, he can represent you on that.
Appreciate you, boss.
You betcha. Make that boat go slow. No wakes.
No, I know, I'm gonna do it. I just had to look at your thing. We gotta wait for him to talk.
Okay. And your name?
I got you.
Catherine Todd.
All right, Ms. Todd, you have been arrested on 2 offenses. One is trespass in a dwelling, and the other is possession of drug paraphernalia. I have examined the arrest affidavit, and I find probable cause as to both. Do you wish to have the public defender appointed to represent you?
Yes.
All right, let's appoint the, well, I don't have information on you, so let me just ask you a few questions.
Yeah.
Oh, you got something? Oh, okay. All right, based on your affidavit, I do find that you qualify. The public defender will be appointed. Your bond on the trespass charge is $500. Your bond on the possession of drug paraphernalia charge is $100.
Your Honor, we'd ask for ROR on both counts. She has 1 misdemeanor conviction for prostitution and no failures to appear. So we'd ask you to, the court take that into consideration.
I do. The problem is that she has no address. So I don't know if we ROR her where we're going, how we're going to be able to get any information to her. State want to be heard?
Yes, Your Honor, the state was going to mention that no community ties have been able to be established, so.
Yeah. That's, so I'm going to leave the bond the way, if you had a regular place you lived, we might let you go because we know we'll be able to contact you there, but
She indicated that she was going to go live at a hotel.
Can I have no FTAs.
I know, the problem is, if we let you go now, we have no way to contact you.
I have a cell phone.
Well, they don't call, they have to send you something.
Okay.
Yeah.
Can I use my mother-in-law's address?
No, because that's not where you're gonna be. The thing is, if we, I'll tell you what I'm gonna do. I'll make the bond on each count $100.
Okay.
So if someone come up with a couple $100, then you can get out. Because the reason we do that is because that way that person has a reason to go and find you. And we don't have to.
Okay.
All right?
Can I?
They're not going to let you plead because of the charge. Yes, because they're not going to let you because of the
Ma'am,
trespass.
you can talk to the lawyer later. It's getting late and I
thank
want to get these people
Thank you.
home before the crack of midnight. All right, what's your name, sir?
Gregory Carson.
Sorry?
Gregory Carson.
Curtis
All right.
Young is mental health, Your Honor.
Mental health. Okay, we'll see him tomorrow. Mr. Carson, you've been charged, you've been arrested on a warrant out of Seminole County. The bond on that warrant is no bond, so you will be held until you are transferred to that county. You also, there's 2. There's 2 warrants out of Seminole County. Each of them has no bond, so you'll be held here until you're transferred to Seminole County to see the judge in those cases.
They'll pick you up in 72 hours.
Are you familiar with it?
No, he's not. That's Seminole County. This is Orange.
All right, next, sir.
John Cunningham.
Mr. Cunningham, you are, let's see. Okay, you're here on an out-of-county warrant, 2 out-of-county warrants for fraudulent use of credit card and burglary of conveyance. Those both have bonds set at $2,000. You also are here, just a moment, on Oh, I'm sorry, you're on a lot of out-of-county warrants. The first two I said were $2,000 each. There are, holy,
It's all one case, it just looks like it's several counts.
several. It's 44. Yeah, 43, I'm sorry. So you're being held on, the out-of-county warrant is on 43 counts of something, and the bond is $25,000 on, hold on, $25,000 on 1 through 20, and then $2,500 on 21 through 26. I'm sorry, 21 through 43. So you're going to be in jail until they send you to the county that issued the warrant, and then you'll deal with the judge there. Oh, is this him? Oh, I already did that one. That's the first one.
No information's been filed in that case, so don't take any action would be my, and it's been more than 33 days.
I don't bond in this case.
Yeah.
Take action on it?
No, we won't take any action on that now. All right. Your name? Please.
Chinese Kaiser.
Okay. You have been arrested on a warrant out of Seminole County for failure to appear at sentencing. Your bond is set by the judge in that county at $660. And if you post bond, you can get out. And I think this is all, is this two things?
No, that's it.
One thing. Okay.
Thank you.
Thank you. And yes, your name?
Danielle Moore.
Ms. Moore, you were also arrested on warrants out of Broward County. There's 2 counts. One is a bond of $1,000. The other is a bond of $100. So for $1,100, you can bond out. If not, you'll be taken to the other county to face those charges.
Okay.
Okay?
You can bond out. Okay.
All right. Okay, the next person I had was a Shakita Walker. Not on your docket, okay. That over there. All right, sir. Tell me your name, please.
Ivan Villanueva.
That's his case right here.
Huh?
His case.
Oh, did I read it wrong? Oh, okay. I've been up since 6:30, okay? All right. John, you cut me some slack here. All right, so you've been arrested on a violation of probation. And the judge that issued the warrant for a violation of probation set the bond at no bond. So you'll be staying in jail until you see that judge.
Well, do what I have to see the judge here or in Osceola County?
It's from Osceola? Osceola County. They'll be sending you down there.
No, they're gonna come pick you up.
All right, sir? Yes, sir. What's your name?
Marvin Kemp. Marvin Kemp.
Marvin Kemp. Okay, what about Jonelle DeCavius, Jonelle Burton?
He refused, and also David Graham refused.
For Burton, can we waive his IA? He's already been adjudicated in competence proceeding, and I believe we represent him on the case that he's out on conditional release for. So we waive his IA.
That's fine. Waive the IA, the bond will, probable cause is found, the bond is stayed.
That was on Burton?
Yes.
Oh, he's already bonded on this case?
No, he's out on bond.
Oh,
What I was saying is that we represent him on that case where he's been adjudicated in competent to proceed on 12/12/2018, so I ask that you take no action.
I won't. No action. All right, Mr. Kemp, you are here on 2 violations of probation, one on possession of cocaine, and one on, I'm sorry, there's more than that. Oh, there's a lot more than that. In CF 16-128, you're here in violation of probation for counts 1 and 2, possession of cocaine, possession of paraphernalia. In 17 CF 3936, VOP on delivery of cocaine and possession of cocaine. in 3935 VOP on delivery of cocaine and possession of cocaine. I'm starting to see a pattern here. In 2017, CF 3907 VOP on possession of cocaine, and in 2019 CF, is this a new case? Oh, a new case. Oh, good. So now you have a new case, which is sale and delivery of controlled substance. Just a moment. Sale and delivery of fentanyl. This is based on a warrant issued by a judge, and your bond in that matter is $7,500. Would you like the public defender appointed on your VOP cases and your new case?
No, I got a private attorney on my VOP cases.
All right.
Because what happened, I went to court.
Yeah.
Go for it.
No, because what I'm saying, sir, is Thursday I went to court, on outside court, for the VOPs, but they locked me up because they said I had a warrant for selling delivery of fentanyl.
Right. But that may be a new violation of your probation.
Yeah, that's what they were saying, because I violated for a charge, but the charge had got dismissed, so I was going to court to get reinstated back on probation.
When you get before the judges that have issued all these warrants.
Yeah, they set a court date already for June the 4th already for the judge.
Okay. Well, you'll be in jail till then.
Yeah,
All right.
I already know.
Okay, sounds good. That's Mr. Kemp. Okay. There's Mr. Poland.
We already addressed him.
I know. I just found another one on here. But I think this is the one we already did.
This is the one we couldn't find earlier, but we addressed both of them at the same time.
I thought so. I remember that. Oh, yeah. All right. Your name?
China Snyder.
Okay, just a minute. China Snyder. Okay, I had Donta Rucker.
He's mental health.
I'm sorry?
Mental health.
And Rasha Russell?
She's mental health also.
Mental health. Well, they're busy today. All right, Ms. Snyder, you have been arrested on a number of charges. Just a moment. Yes, you've been arrested on charges of possession of firearm by a convicted felon, possession of ammunition by a person who committed a delinquent act, possession of cocaine within 1,000 feet of a place of worship with intent to sell, possession of methamphetamine with a weapon, sale and delivery of cocaine within 1,000 feet of a park, possession of drug paraphernalia, and possession of cocaine with intent to sell within 1,000 feet of a park. Would you like the public defender appointed to represent you in these cases?
Yes.
All right, based on your affidavit, the public defender will be appointed. Your bonds on the 7 counts are as follows. Count 1, $150. Count 2, $150. Count 3, $10,000. Count 4 is $10,000. Count 5 is $10,000. Count 6 is $100, and count 7 is $10,000. I guess, apparently Judge Carter, what does this say? State to provide supplemental complaint.
Yes, Judge, and I didn't receive here in the packet supplemental affidavits, if I may approach.
Yes, please. Oh, okay. Oh, these are the return things. All right. Based on that, I find probable cause, and the bonds are set by Judge Carter.
Thank you, Your Honor.
All right? That's right, these are all returns. Didn't realize that. Okay. Please state your name.
Renisha Stower.
Okay. This is another case where probable cause was not found, and the state attorney's office had 24 hours to supplement that. And this is a co-defendant of the other. It's the same affidavit?
I believe some of it is the same at least. But this is what.
Go ahead and hand it to me, and I think it's probably pretty much the same. Thank you. All right, based on the supplemental affidavit, I do find probable cause exists, and the bonds will be set as indicated on Judge Carter's order of commitment. $10,000 on count 1, which is possession of cocaine within 1,000 feet of a place of worship with intent to sell at $10,000. Possession of methamphetamine with a weapon is $3,500. Sale and delivery of cocaine within 1,000 feet of a park, $10,000. Possession of drug paraphernalia, $100. Possession of cocaine with intent to sell within 1,000 feet of a park is stayed at $10,000. I don't think I've appointed the public defender yet, have I?
I don't remember.
Oh, they were appointed yesterday, so, okay.
Okay.
You've already been appointed. All right, the next one, your name, sir?
Tillman.
Mr. Tillman. This is another one. Does the state have a supplemental affidavit?
I do, Your Honor.
Yes, you may. Yeah, that's what I thought. Oh, this is the same. Okay.
I think they're coded.
Yeah, they are. All right. Court finds probable cause on this as well. The bonds are stayed as they were. Public defender has already been, has a public defender, or
I don't know if it was appointed yesterday, but go ahead and appoint us, and if there's a conflict, we'll deal with that later.
public defender will be appointed in those matters. Your bonds, sir, on counts 1 through 4 are $150. Count 5 is $10,000, and count 6 is $100, and count 7 is $150. Thank you. Okay. All right. Your name, sir?
William Brumfield, sir.
Mr. Brumfield, you have been arrested on a violation of probation warrant out of Orange County for violation of probation that we put on charges of possession of cannabis, the intent to sell and possession of drug paraphernalia. Your bond is set by the judge at no bond, where it will remain until you appear before the judge. You are also apparently on bond on carrying a concealed firearm on 2019 CF 5170.
Yes, sir.
Any requests from either side on that one?
He's no bond on the VOP, right?
Right.
I
I'll take no action.
Yeah, okay.
Okay, thank you, sir. You're all done. Your name, sir?
Jeffrey Smiley.
Mr. Smiley, you have been arrested on charges of possession of MDMA and possession of alprazolam. I've examined the arrest affidavit and find probable cause. Would you like the public defender to be appointed?
Yes, sir.
All right, based on your affidavit, you qualify, so I will appoint the Office of the Public Defender to represent you. The bonds on the two counts, count 1 is $1,000 and count 2 is $150. Those bonds will be will be stayed. Oh, you also have, all right, a violation of probation, maybe a couple of them. 16 CF 6101, you have a warrant, warrant for violation of probation. Is this a warrant or on view? Hold on a second.
One is on view, one is
Okay,
view.
the one I just mentioned is an on-view arrest for violation of probation. I find probable cause exists in that affidavit, and your bond is set at no bond pending your meeting with the judge in that case. The other case is a warrant for violation of probation. In that case, the acts were aggravated stalking and criminal mischief. The bonds in those are no bond, and you'll be held pending those. If I haven't already asked you, because I'm getting blurry, would you like the public defender appointed on any new charges?
Yes, sir.
All right, public defender will be appointed to represent you on those charges. All right, Mr. Dempsey? Sir. All right, you've been arrested I'm sorry, your new charge is disorderly conduct. Just a moment. I don't find probable cause for disorderly conduct in this case. I'm going to RR the defendant. I don't really think that this can be fixed, so he'll be he's on ROR now for possession of amphetamine, but I'm not going to take any action on that.
We appoint the public defender for this case?
Sure. You want the public defender appointed?
Yes, sir.
Done.
So I'm going home today, sir?
There you go.
You're on this right now.
Thank you, sir.
You bet. All right, next. Who's up next? All right, so your name?
Larry Lucas.
All right, Mr. Lucas, you have been arrested for camping, prohibited exceptions. Give me just a moment. I do find probable cause from the affidavit that you violated the city ordinances against camping. According to this, you were out on bond on possession of methamphetamine and trespass on property after warning. Your bond on the camping is set at $250. Would you like the public defender appointed?
Yes, sir. Yes, sir.
Yes?
Yes, sir.
Okay. One question. Were you camping because you had no place else to? Never mind. I can't ask that. I'm sorry. I'm sorry. Do you have any income?
Yes, sir.
What income do you have?
Social Security and pension.
All right. How much is that a month?
How much do you get in Social
I'm
Security?
trying to count it up.
Oh,
But
okay.
seven something is Social Security and about like 100 something in my pension.
And how much was the pension?
100 and something, about $60,
100 something for the
$160,
pension?
something like that.
All right. Do you have any other source of income?
No, sir.
You have any, you own any real estate,
No, sir.
jewelries, boats?
No, sir. I don't,
Cars?
No.
Okay. You won't be violating the no wake zone, will you? We had another guy in here. Anyway, okay, I'm going to appoint a public defender to represent you in this case. I am not going to take any action on the other cases he's on bond for. The bond on this case is $250.
We'd ask, since this is a nonviolent misdemeanor, and it's the state's non-monetary bond policy to advocate for ROR on charges like this, all city ordinances.
Ready? Advocate.
State has no objection to ROR.
Then RR it will be. Boldly advocated. Boldly advocated.
Thank you, sir.
All right. Next. Sir, what's your name?
Michael Mason.
All right, Mr. Mason, you were picked up on a charge of panhandling. Let me look at the arrest affidavit very quickly. All right, I do find probable cause that that offense occurred.
Is your plea, sir?
You want to resolve it today? Yeah, sure.
Yes, sir.
Okay. You want to chat with the public defender real quickly?
Yeah.
What is the plea?
I don't know. We have to ask the judge.
What is your plea?
Does he have 1 or 2 days?
Yes.
2 days. An offer from the state would be credit time served for 2 days.
Thank you.
Okay. So, you want to sign the plea form?
Yes, sir.
Based on the arrest affidavit, we'll find sufficient evidence, and we'll accept the plea as freely and voluntarily made. Do you understand all the rights you're waiving on that piece of paper?
Yes, sir.
Any questions about any of them?
No, sir.
All right. Then I'm going to sentence you to time served,
Sir.
and good luck to you.
All right, thank you, sir.
All right. Are you Mr. Scalera?
Yes, sir.
All right. You have been charged with the offense, the heinous offense of camping. It's late, and I should make a joke, but I'm just too dang tired. I do find probable cause existed from the arrest affidavit for that offense. Would you like to have the public defender appointed?
Sir, I'm naive. I don't know how to answer that. I mean, I would hope to get ROL or ROR. whatever.
ROR?
I would
He's
hope so.
asking you if you want a lawyer. Do you want me to represent you today?
Could you represent me today?
I can.
Yes.
Yeah. Okay, we'll
Yes.
appoint the public defender to represent you today. The only reason I can't ROR you is because we have no way to contact you. So we'd have no way to tell you when to get back. Do we have any information about his history?
Only 2 misdemeanor convictions.
Okay.
It's also the state's non-monetary bond policy to advocate for ROR in charges such as camping.
If we had any way to contact him, I would, but does he want to resolve the case right now?
That's up to him.
Well, you're his lawyer, you
Do you
talk
wanna
to him about
resolve
it.
Can you?
Yeah.
Yes.
How many days credit does he have? Would the court accept a credit time served offer?
Absolutely.
All right.
All right, sir. Look at that plea form. Now, understand that what you're doing is you're admitting that you broke the laws that violate, that prohibit camping.
Okay.
Okay? You
Yes,
understand
sir.
that?
Yes, sir.
Okay. And there's all kinds of rights on there that you're waiving, so make sure you understand that too.
Okay.
You
Yes,
got
sir.
an attorney with you. All right?
Yeah.
All right, sir. Based on the evidence presented in the affidavit, I'm going to find that sufficient evidence exists for camping, and I'm going to find you guilty based on your plea and sentence you to time served. And going to have to find someplace else to sleep.
Yes, sir.
All right? All right. That's it.
Thank you, Your Honor.
Thank you.
Have a good day. Good luck to you.
Now, there's a little bit here. What is this? What is this? Okay. What is this? All right. Oh, that's that list. So I seem to only have one left. For my imagining something. No? I have a black Nell. Terrell. Huh?
What kind of charge is it?
Possession of cocaine. Bonded, do you think? So are we done? Hallelujah. Okay. And the state's familiar with this?
I just received copies this morning, so I've reviewed that already.
Okay, and I see there's, okay, great. I saw the email.
Okay, an email correspondence
Yep.
between the attorneys who were in Division 12.
All right, there you go. So you just want, you want the whole packet for her, just?
Yeah, she could take the whole packet. That was just for the court so that you knew we weren't trying to run one by you or something.
Probably gotten away with it.
What's that?
You've probably gotten away with it. I don't know. All right, so what are we doing first? Osceola. This one? Okay, oh. I would have checked my makeup if I didn't have a TV. Okay. Yeah, I'll just pass them off to you.
Okay, great.
We'll just do it that way. There you go. Right. All right, good morning. We are here for initial appearances. The first case will be Mark Anthony Maldonado.
Alicia Smith on behalf of the Public Defender's Office, Judge. And after we do Maldonado, the deputies asked if we can do Dixon next.
Sure. Mr. Maldonado, good morning. You have been, you're in custody on a violation of probation warrant. Your bond is presently at no bond. I believe you have is the public defender already appointed in this case?
No, Judge, he asked for the Public Defender though.
All right, do you want to have a public defender appointed, sir? Can you hear me? I can't hear him at all.
Yes, sir.
Okay. Then the court will appoint the public defender. Do we have a hearing date for him, or he'll be noticed? Okay. Anything else from the public defender?
No, Judge.
Or state?
No,
all right. Thank you. And what was the one you wanted me to call next again?
Dixon, Valerie Dixon.
Valerie Dixon. A second. Okay. Okay. All right, Valerie Dixon. Trespass after warning. Good morning, Ms. Dixon. Hello. You've been charged with the crime of trespass after warning. I've examined the affidavit. I do find there's probable cause for detention. Your bond is set at $500. You do qualify for pretrial release. So the court will, pass the order along. There we go, getting it right. The court will grant pretrial release, and you will be given notice of future court dates and arraignment. Would you like the public defender to be appointed?
Oh, no.
I couldn't hear you.
No, sir.
No.
No.
All right.
No, yeah. She said no, Judge, it's just a delay.
Okay, that's all right, I got it. All right, anything else?
No, Judge.
From either party? No? All right. That will conclude that case. Yes.
This is Margaret Jones with PTR.
Yes,
I was wondering
I do.
if Ms. Dixon could have a mental health evaluation and maybe mental health conditions of PTR.
Does the public defender want to have any input on that?
Judge, we just asked for straight PTR in this case without the mental health condition.
Well, based on what I read, I think the mental health evaluation is probably a good thing. And whatever assistance it can give to her. So the court will order a mental health evaluation as part of the pretrial release. Thank you. Do I just pass this off to you? Okay. All right. Let's call Brian Michael Zushin. There's a number of matters. Good morning. Just take me a moment here. There we go. All right. You are here on a number of matters. The first is charges of possession of marijuana under 20 grams and possession and use of drug paraphernalia. I do find probable cause for count 1, possession of marijuana under 20 grams. I do not find a probable cause for possession or use of drug paraphernalia. The arrest affidavit does not mention any items of paraphernalia that were found. The bond on count 1 is presently set at $500. You do qualify for pretrial release. We'll wait till we get to the end to determine that, but you will get, let me start over. You will be given PTR as to this case. All right. Okay. Huh? Oh, I'm doing this one? I did the possession of paraphernalia and cocaine first. Oh, I'm sorry, I didn't give them all to you. There you go. I had them all separated out and didn't give them to you. Okay, so that's the... Got those in the right order? Okay. So PTR, PC's found, PTR on that one.
Okay.
And I don't think I signed it.
I'm sorry,
And no PC on count 2. That's correct. Yeah. And I need to sign it. I didn't sign those orders. Sign them later? Okay. All right. So that is that case. The next case is charge of driving under the influence of alcohol or drugs, first offense. I've examined the arrest affidavit. I do find probable cause on that case as well. The bond is set at $500. The court will put this case on PTR as well. And we'll address the public defender at the end of all of these cases. All right? You got that one? All right. The next case is resisting without violence. I have examined the arrest affidavit, and I do find probable cause for that charge. The bond was set at $500. The court sets release at PTR. Oh, there's one that got missed. That's this one. The next case is a charge of fleeing and eluding high speed with disregard of public safety and reckless driving. I've examined the arrest affidavit, and I do find probable cause for those charges. The bonds are presently set at $500, and the court sets release at PTR. All right. The next one is fleeing and eluding high speed with disregard of public safety. The court has examined the arrest affidavit and finds probable cause. The court will set, the bond is presently set at 0. Court will set PTR as release for this case. The next case, the last case, is a charge of misdemeanor stalking. The court has examined the arrest affidavit and does find probable cause for that charge. The court will stay the bond at $1,000 on that case, and there will not be PTR on that case. Special condition in that case is that, sir, you are to have no contact of any kind with the victim in that case. I want to make very clear to you what that means. It means you do not contact her. It means you do not call her, text her. You do not reach out through social media. You do not try to attract her attention through social media. You do not have a friend reach out to her. You do not contact her in any way. And that also includes you should not come within 500 feet of her place of residence or 100 feet of her vehicle should you see her in a vehicle. Do you understand that, sir?
Judge, I did want to make a
Okay.
cause argument as to the stalking charge.
Yes.
On the police report,
Go ahead.
There's no no indication of any verification in terms of the multiple pages that the alleged victim indicated were made. The only incident in terms of physical presence was when they were in the same location at which he left, which they both vacated. There's nothing in the police report to indicate that the police looked at either of the pages that she indicates that he made, or that they were able to verify that he was the maker of those pages. So I didn't know that I didn't think there was probable causes for stalking since they were both in a mutual location, aside from the multiple pages they were supposedly made.
Well, I think what the court found was that the acts contained in this affidavit on that day, combined with the prior acts of creating the fake pages on social media and attempting to contact her, are multiple acts that would constitute stalking taken as a whole. That is probable cause there is that they would constitute stalking.
Okay.
Thank you, counsel. Now, sir, would you like to have the public defender appointed to represent you temporarily in these charges? Was that a yes? Okay. And the public defender will be appointed to represent the defendant in all these charges. You're all caught up? We're good? Okay. There's the next one. You know what? We'll sign them later, you said, right? Okay. The next case is Rafael Santiago Corsino.
He's at the hospital, Judge. Can we reset him for tomorrow?
Yes. So that'll be reset for tomorrow. Okay. Carmelo Jesus Rosario Huey.
He needs the interpreter, Judge. Do we have an interpreter?
Dalia Romero, Spanish interpreter, for the record.
Okay. Will you have a Spanish interpreter? Sir, you have been arrested on charges of dealing in stolen property, false verification of ownership information in a pawn transaction, and petty theft.
Señor, usted ha sido acusado de haber estado negociando con mercancía robada, haber provisto información falsa a una casa de empeño, hurto menor, como un primer delito también.
I've read the arrest affidavit and find probable cause as to all three charges.
Yo he leído la affidavit acusatoria y he hallado que hay causas que respaldan la acusación en los tres cargos.
Does the public defender or state attorney want to be heard on the conditions of release?
¿El fiscal o el defensor público quieren decir algo en cuanto a las condiciones de libertad?
Your Honor, may I ask PTR what the history is?
La fiscal está preguntando cuál es el
It
historial.
appears that he is on supervised state probation for case 2019 CF 706, petty theft, 2 priors. That's what it says on the initial appearance information sheet.
Aparentemente está en libertad vigilada o probatoria por un caso y por otros 2 casos de hurto menor.
Your Honor, I also have some other criminal histories. Would like to hear that.
Yes, go ahead.
Okay. Since 2009, he's had 11 convictions, and that includes a battery, trespass, a cocaine charge, 4 larcenies, including the one that he's on state probation for, the petty theft, with 2 priors.
Do we know if a violation of probation has been filed on the other case?
No, we do not know
Se está
that yet.
comentando que usted tiene un historial desde el 2009 con 11 condenas, unos por casos de agresión, entrada ilegal, tenencia de cocaína, 4 por hurto menor, incluyendo los 2 por los cuales está en probatoria vigilada o libertad vigilada. Actualmente, el juez ha preguntado si ya se ha formulado una orden de arresto en el caso de incumplimiento de probatoria. Aparentemente no.
Sir, would you like the public defender appointed to represent you temporarily?
Señor, ¿usted quiere que se le designe el defensor público para que le represente temporariamente?
Lo que pasa es que yo no tengo
don't have to be there in charge. Yes.
All right. Court will appoint the public defender temporarily. Does the public defender have any comments about the bond?
Se le designa el defensor público temporariamente y el defensor público tiene comentarios que hacer en cuanto a la fianza.
I just asked the bond to be set, I believe per the warrant, the bond was set at $2,800 total, so I asked that bond be remained and no action as to any alleged or potential violation of probation since it's a warrant case, and I'm unable to verify if this would have predated the probation sentence or not.
All right. Then the
Estoy pidiendo
court
que se le
will
dé la...
stay the bond as established previously.
El juez va a determinar que la fianza es la misma que previamente se había predeterminado.
All right. Thank you, sir.
Gracias, señor. Eso es todo. La misma fianza. Same bond.
All right. Next case is Javier Rivera Pagan. Sir, would you please state your name?
Javier Rivera Pagan.
Sir, do you need the services of the interpreter?
¿Usted necesita los servicios del intérprete, señor?
No? Okay. You've been arrested on charges of possession of controlled substance without a prescription and possession or use of drug paraphernalia. The court has examined the arrest affidavit and does find probable cause for both charges. Your bonds were originally set at $2,500 and $500. You qualify for pretrial release, so the court will permit you to pretrial release. Anything further from the state or defense?
Nothing from the state.
He was deemed not indigent.
This is the first time I've done IAs, folks, so I'm relying on all of you to let me know if I forget anything.
No, Judge, he was deemed not indigent by the clerk, so I don't believe he will be appointed.
Yes, I recall that. Thank you.
Your Honor, this is PTR.
Yes.
I would suggest that he have
Yes.
random drug screens.
Oh, excellent suggestion. So we'll add random drug screens to the PTR. All right, Mr. Daniel Ramdas. Sir, you've been arrested on a violation of probation community control warrant. That warrant indicates that your bond is no bond. Court will stay the bond as no bond until you see the judge who will hear your VOP. Would you like the public defender temporarily appointed to represent you? All right, the court will appoint the public defender to represent the defendant. Oh, there's the order. I'm still working on this process here. Okay, here's that guy. All right, next case is Chad Perry. Please state your name, sir.
Chad Perry.
All right, Mr. Perry, you have been arrested on warrant for violation of probation out of Osceola County. Your bond is presently set at none. The no bond will be stayed until such time as you see the judge that issued the warrant for your arrest. Would you like a public defender appointed for you in the interim?
Yes, sir.
All right. Court will appoint a public defender temporarily to represent the defendant. There you go. Okay. Mr. Henri Josette,
He bonded.
or Jose?
He bonded.
He bonded, okay. All right, there you go. Victoria Rosina George. Would you please tell me your name?
Victoria George.
Hi, Ms. George. You were arrested on a warrant, a VOP warrant, out of Broward County, Florida. The warrant dictated that you should be held without bond and transported back to Broward County to face those charges. You will be held without bond pending resolution of this matter. Would you like the public defender appointed for any matter that may happen here in Orange County? All right, we'll appoint the public defender temporarily. Thank you. All right, the next case is Amanda Freeman. Would you please tell me your name?
Amanda Freeman.
All right, Ms. Freeman, you have been arrested on charge of simple battery. I've examined the arrest affidavit, and I do find probable cause for that offense. Your bond is presently set. What is your present bond? None. You're being held without bond at the time. You qualify for PTR. The suggestion is bond with PTR. Someone please define that for me.
Judge, I'd ask.
So that's a monetary bond?
Yes, Judge, it's bond with condition of pretrial release. I asked for either straight PTR or a monetary bond, not both conditions, Judge.
All right. State want to be heard?
State would have no objection to straight PTR.
All right. Our PTR folks, you want to be heard on this?
Yes, Your Honor, she does not qualify for straight PTR. She only qualifies for a bond with PTR due to her prior.
Right. Oh, I see. 7 prior battery arrests out of Georgia. So the court, sorry?
Sorry, she also has an outstanding warrant in Georgia with no extradition.
Oh, I see that. Okay. Well, the court will not put on PTR alone, but we will set a bond. Would the state or defense like to be heard on the amount of the bond?
Judge, I'd ask for a $500 bond in this case. Ms. Freeman is pregnant. She's actually scheduled to be induced this coming Monday. So she needs to be released. Well, we're asking for her to be released so she can go out and give birth in a safe environment due to being pregnant at this point. So we'd ask for a $500 bond in this case. In terms of additional release conditions, it's my understanding that the alleged victim, her brother, doesn't reside there. He was only there visiting. Pretrial release hasn't been able to make contact with him, but she resides there with his mother, so I would ask for her to be able to return home as well.
Does the state want to be heard?
Your Honor, based on her condition of being pregnant, the state has no objection to setting a monetary bond. I think the PD requested $500. Just even if they maintain separate residences, the state would request a no hostile contact order and
All right.
such to be placed.
The court will set the bond at $500. The condition of bond will be that you have no hostile contact with the victim in this case. That means that you are not to get into any kind of argument with him. That means if he tries to start an argument with you, it is your obligation to leave. He will not get in trouble for getting in a fight with you, but you will. So if he tries to start trouble with you, you go the other way. If he comes to the house, you go sit in the bedroom by yourself. You understand that?
Yes, sir. Sir, is it able to, I could get a restraining order or something? I don't want that contact.
Yeah, we can't do that. You'd have to file for that in the Osceola County Courthouse, but I can't do that today. All right? Thank you. Oh, yes. Would you like the public defender appointed temporarily to represent you?
That's fine. Yes, sir.
All right. Public defender will be appointed temporarily. Thank you. That's all. You can go have a seat. Okay, Michael Anthony Fabiani. Please tell me your name, sir. All right, Mr. Fabiani, you are charged with battery. I believe this is a domestic violence battery on your ex-wife. The court has examined the arrest affidavit. The court does find probable cause for that charge. You're presently being held at no bond. Would the state or defense, well, first of all, sir, would you like the court to appoint the public defender to represent you temporarily?
Yes, sir.
All right, the court will appoint the public defender to represent you temporarily. Does the state or defense want to be heard on the issue of bond?
Judge, I asked for straight pre-trial
Your Honor,
in this case. I'm sorry, Kate.
may we hear from PTR if there's any
Yes.
history?
Well, PTR, go ahead, because I have your recommendation that he does qualify.
Yes.
But go ahead.
Yes, Your Honor. Prior to this case, in 1996, he had a burglary with assault, carry a concealed weapon, and trespass, and those were up for adjudication with no. He had a 2-year probation for grand theft in 1992, and in 2008, a battery which was dropped. 2014, he had a sexual assault that was dropped, and a violation of a domestic injunction that he did receive 1-year probation.
So he has a prior conviction for violating a domestic violence injunction?
Yes, sir.
Okay. State, you want to be heard on this?
And PTR, he qualifies for PTR?
That's what it says, yeah.
Yes, ma'am.
Your Honor, based on the history, the state would request a monetary bond to be set.
Yeah, the court will set a monetary bond based on the prior history. Does either side want to be heard on the amount of the bond?
I'd ask for a $500 bond, Judge, since he does qualify for PTR as a lower moderate.
Your Honor, again, based on the history, the state would request a $1,000 bond.
Yeah, I'm going to set the bond at $1,000. The conditions of release is that you are to have absolutely no contact with the victim in this case. That means you cannot call, you cannot write, you cannot text, you cannot email, you cannot communicate with her in any way. The only person who is permitted to communicate with her on your behalf is your attorney. You are not to have any other human being on earth contact her for any reason on your behalf. You're not to go back to the residence where she lives. You're not to be within 500 feet of it. You're not to be within 100 feet of any vehicle that she's in. Do you understand these conditions, sir? All right. Without the ruling of the court. Okay, let me, you're right, I did put that down.
Okay.
A couple other conditions, sir, Mr. Fabiani, I also added, yeah, thank you, sir, I'm sorry, I'd forgotten about this. Were you living at the same residence?
My understanding, Judge, is they live together and work together within the residence, so yes.
We have our company.
Okay.
We all work together.
All right, so you're not to return to the residence. You're going to have to get a separate residence, and you may return to the residence one time with law enforcement to retrieve your personal items, any items essential for work. What kind of work do you do out of the house?
We do property appraisals and PI.
Property appraisals.
I'm sorry, what?
Property appraisals and PI.
Property appraisals? Okay, well, you're going to have to do that from another location until this matter is resolved. Anything else from either counsel?
No, Judge.
No, Judge.
Or from the clerk? Nope, we got it? All right, good to go. Thank you, sir. Okay, Ashley Ann Emmond. All right, ma'am, you have been arrested for a violation of probation. It was an on-site arrest. based upon a failure to pass a drug test. You're presently being held at no bond, is that correct? Being held on no bond pending your appearance before the judge who is monitoring your probation. Does the other counsel want to be heard on the subject of bond?
If the court is inclined to grant a bond, in this case, Judge, you ask for a $1,500 bond.
State?
The state would request that the bond stay at 0 until she is present before the judge handling her case.
The court will set a bond in this matter because this was a drug screen failure, not a separate new crime. So the court will set a $1,500 bond in the matter. Thank you.
Public defender appointed.
Oh, yes, I'm sorry. Ma'am, would you like the public defender appointed for you temporarily until you see the judge?
Yes, sir.
All right, the court will appoint the public defender. All right, next case is Richard Delgado George.
Good morning, Your Honor.
Good morning. What's your name, sir?
Ricardo Delgado George.
All right, sir, you have been arrested on a charge of battery. And I do believe this is a domestic violence case. I've read the arrest affidavit. I do find probable cause. Would you like the public defender temporarily appointed to represent you?
He's going to hire a private judge.
All right, and the court will not appoint the public defender at this time. The present bond is set at no bond. Would the state or the defendant like to address the issue of bond?
May we hear the history from PTR?
Yeah, PTR, could you give us a little background?
Yes, sir. In 2008, he had a possession of marijuana with intent, a battery domestic, possession of paraphernalia, flee and elude, and then careless driving. He also had a VOP. He served a prison term from selling marijuana in August of 2013. In 2014, he had a possession of marijuana, paraphernalia conviction. He had 6 months probation. 2016, he had a possession of marijuana, destroying evidence and passing counterfeit, and that was dropped. He also has he had conviction in Louisiana and Maryland. Maryland, he was placed on probation for that, and he's on federal probation right now. Expires January the 3rd, 2021 for illegal use of a credit card.
All right, sir, you want to tell me anything about your financial situation before I decide on the monetary bond?
I'll make the argument, Judge.
He didn't want you appointed, so you can't. Huh?
Sir,
No, I mean, he said... I'm sorry, just let me clarify one thing. Hold on. I thought he said he did not want the public defender.
Right, for initial appearance.
Or did I not ask him?
You did ask the judge. You said he was going to hire a private for initial appearance purposes. I was going to appear on his behalf.
All right, sir, do you want the public defender to appear on your behalf for purposes of this hearing?
Yes, sir.
Okay, then go ahead, ma'am.
Judge, I asked that a bond be set in this case with no more than $1,500. While I understand pre-trial release has read its history, there's no indication that there's been any undue violation or that federal probation has been violated in any way. So I'd ask that you be giving a bond in this case with no more than $1,500.
State?
Yes, Your Honor, the state has no objection to setting a monetary bond, though the state would request that it be higher than that, considering his history, as well as the history that he has in other states. That's all.
Sir, Sir, do you own any real property, like houses, land, anything like that?
No, sir. I have a vehicle in my name. That's it.
Okay, what kind of vehicle do you have?
An Audi,
What year?
2011.
All right. Do you have any bank accounts?
Yes, sir. I'm employed.
All right, where do
too.
you
I
have
work-
bank accounts?
I have a bank account with Wells
Where do
Fargo.
you work?
I have a bank account with Wells
Okay.
Fargo. I work at the airport for Swissport. I'm contracted through Spirit Airlines, sir.
Right. How much money do you have in the bank?
Probably about, I want to say at least $500 if anything. You know, I make payments on my credit
Okay.
card and stuff like that. So,
Do you have any rich relatives?
I have family that, I mean, if needed to ask them for a lend of money, yes, that is possible, sir.
Okay, are these people that are local?
Yes, family members.
How long have you lived in Osceola County?
I lived in Osceola County for since 2008, sir.
Where'd you live before that?
I lived in Maryland. Prior to that, sir.
All right. Go ahead. Prior to that, where'd you live?
I was born in New York, lived in Maryland, and I live in Florida, sir. This is where I reside at. My kids live
All
down
right.
here. All my kids, my two older kids go to the same school, which is not even 10 minutes away from my house, sir. So.
All right. Well, because the defendant is on, I guess, multiple probations, federal and state, if I heard that right.
It's just one judge, it's just the federal.
Just federal? All right. Because you're on federal probation and these events would violate that probation if you were convicted of them, I'm going to set the bond at $5,000. I want you to have a big stake in this game because we need to make sure you come back for court. So it's going to be $5,000. If you are released on that bond, you'll have absolutely no contact of any kind with the victim in this case. It means you're not to talk to her, not to text her, not to write her a note, not to ask your friends to talk to her. No one is allowed to talk to her on your behalf at all. The only person that can speak with her is if you get an attorney, if you hire an attorney, that attorney is allowed to speak with her. But aside from that, no one else can. You're not to return to the location where this occurred. Any other conditions that the state would like me to impose?
Maintain separate residences, Your Honor, if they don't
Maintain
already.
separate residences, that's correct. I think they already do, but don't remember. Yeah, maintain separate, anything else?
Judge, instead of the no return, can we just have the maintain separate residence? My understanding is that it's his mother's residence, so the alleged victim, doesn't actually live there, that she's in the process of moving. So we can have the maintain separate residence if she has in fact vacated.
Well, if she has vacated, he is not to go to her residence, wherever that is. If she vacates the mother's residence, then he can go back there. But he is not to go into any residence where she is.
Okay, so no
We'll make it even that broad.
And maintain separate residence.
No contact. He cannot enter any residence that she occupies, even temporarily.
Okay.
All right, anything else from the state?
Nothing, Judge.
Anything from the defense?
No, Judge.
Thank you.
All right, then that'll conclude this case. All right. I think this is our last one. Julian Lynn Bliss. Please state your name. All right, Ms. Bliss, you have been picked up on a warrant for violation of probation issued by the judge with jurisdiction over your case. The bond was set at none. That bond, no bond, will be continued, subject to your appearing before the trial judge. Would you like the public defender appointed in the interim?
Yes.
All right, court will appoint the public defender temporarily to represent the defendant. Next, you'll be notified of your next hearing date before the court. Anything in the state or defense?
Nothing from the state.
All right, then that concludes all, I believe that concludes all of our Osceola County cases.
Yes, Judge.
Anybody care to dissent that?
Nope.
All right, thank you very much, folks.
See you tomorrow.
That was the one that bonding. All right, so, these Spanish cases, right, interpreter cases. All right, so we have cases requiring the use of our interpreter. So we, I'm sorry, what?
BCR. Switch over to BCR.
Oh, BCR? BRC?
BRC, sorry.
Okay. All right, so now we're over to BRC.
I need to put their names on the record.
Okay,
For the court reporter.
right. They bring him in here, right?
Huh?
They're coming live, they're not on video.
Yeah.
Okay. So the first case we're going to call, well, let's see who we have here. What's your name, sir?
Eric Texidor Rosario.
I don't think that microphone's working very well. I can't hear anything.
Eric Texidor Rosario.
Okay.
Rosario.
All right, there it is. All right. Mr. Rosario, you have been arrested on charges of possession of firearm by a convicted felon and possession of ammunition by a convicted felon. I'm sorry, these were warrants issued by a judge. The bond in those matters are set at $4,000 for possession of firearm by a convicted felon and $150 for possession of ammunition by a convicted felon. Those bonds will be stayed. Would you like the public defender appointed temporarily?
Yes.
Right, the court will appoint the public defender temporarily for purposes of representing the defendant. There you go.
That's all.
All right, anything else from the state or defense? All right, thank you, sir.
Thank you very much.
Please state your name, sir.
Felipe Arujo de Lima.
Felipe Arujo de Lima.
All right. Sir, you have been arrested on a out-of-county warrant for a charge of stalking. The judge who issued the warrant indicated that you should be held on no bond pending your transfer to that county. Would you like the public defender appointed to represent you temporarily?
Yo tengo un abogado en este caso. Necesito, posso después que yo tengo uno.
I do have an attorney in this case.
You do?
Do I need one?
I believe not.
What county is the warrant from?
¿De qué condado?
It's Osceola, it appears.
Este condado de Osceola.
I'll look it up.
Yeah, it appears to be Osceola.
And Your Honor, for the record, I believe this defendant speaks Portuguese versus Spanish. I was able to understand him, but maybe for future paperwork, it needs to say that he's a
Portuguese?
interpreter.
Sí.
All right. So you'll be going to Osceola County to see the judge.
Ahora. Ahora?
Now?
How's the process?
Well, I'm not taking you in my car.
No lo voy a llevar en mi carro.
Sorry, because it's my first time. It's
I
new.
understand. I don't know exactly.
I don't know nothing about this case. I'm not out to the country. I don't know what's happening.
I understand. I don't know what this transportation schedule is, but as soon as they can. 24 hours?
Okay.
What they said.
Okay.
Thank you, sir.
Gracias.
So we're not going to appoint the public defender at this time. Got an attorney down there. I thought we had one more. No? So Candido bonded? Okay. Have I reviewed these? Oh, okay. I have reviewed this one. I did, yeah. All right, Mr. Barber.
Good morning, Your Honor.
Good morning. Sir, could you tell me your name?
Christopher Shazani.
All right. Sir, you have been arrested on a charge of battery, which is a domestic violence case. I've examined the arrest affidavit. I do find probable cause for the charge. Presently, you're being held on no bond. Would counsel like to be heard on the subject of bond?
Yes, Your Honor. He has no prior history at all. He's not a flight risk, Your Honor. He presents no danger to community. We'd ask that he be released on his own recognizance, or if the court's not willing to do that, we would ask for a monetary bond of $500, maybe up towards of the maximum of $1,000. I know it came in as domestic violence. Based on the four corners of the arrest affidavit, it does state in there that they did not reside together, so it wouldn't actually properly be categorized as domestic violence, which we think would make it more appropriate for release on his own recognizance, Your Honor. Additionally, he was the sole occupant of that residence. The alleged victim does not reside there, so there are no issues about cohabitation, and so we just want to make sure he can go back to his own home.
All right. I did not get that impression from the arrest affidavit that they did not live together. Where is that?
If Your Honor looks on the first page, it goes 1, 2, 3. That fourth paragraph in the middle, the bigger one, the second line does state that they went back to his place, which indicates that it's
You're
not
right.
hers.
You're right. Okay. Thank you. Anything from the state?
Your Honor, just letting you know that the state has already started a process to transfer this to the governor's office, so any way Your Honor would like to handle this.
The governor's assignment. Yeah, I figured that was what was going to happen.
Yes.
All right. The court will, in this case, grant ROR. There is no prior history. The conditions of ROR are that you can have no contact of any kind with the victim in this case. No calls, no phone messages, no gifts, no cards, no reaching out through social media, no putting posts on social media to attract her attention, literally no contact of any kind. The only person that can contact her on your behalf is your attorney, Mr. Barber. Nobody else. Understand?
Yes, sir.
All right. All right.
Thank you very much, Your Honor. Have a great weekend.
You too. Thank you.
So does that mean all my battery DVs are getting ROR?
They have his background, yeah. Oh. Does look like it's a dating case, though, not a domestic case.
Yeah, I work in the DV division, and usually they come in as domestic, and then they transfer them out when they figure out it's not.
Yeah. Sure, let's do these. Yep, love it. Great idea. Okay, so we've got a few here that I have reviewed, so let's go ahead and call them. Joseph Murillo. I've also completed examining Stephen Polin, Carlos Torres Cardona, and Mandel Stewart. If any